Items for pronouncement of judgment. Item number 20, WPC 5826 of 2022.
Petition dismissed.
Item number 21, arbitration number 6 of 2024.
Appeal allowed.
Item number 22, CRPIO 128 of 2024.
Petition allowed.
Hearing matter, my lord. 2011 matter, my lord. Any date, my lord? Next week.
Hearing
Hearing.
in the month of November, last week of November. Any date in the last week of November.
Wait, please, Lordship. Lordship, one IA for condemnation of delay next week, Lordship.
On 30.
CRP, unlisted
On
matter,
30.
the urgent matter may be listed for tomorrow. Because civil proceeding is going on 25th is fixed for cross examination.
Oh, motion.
No, IA file. Yes.
Okay.
May I please, your lordship,
Huh?
with the consent of the respondent, I beg to mention item number 7. The matter may be taken in here on the first week of December.
And for the responded, your lordship.
As agreed by learned advocates of both sides, recess shall list the matter on.
First week of December.
5/12.
Highly August.
Okay.
May I please, your lordship. Lordship, I beg to mention for listing of one RFA and one MSc will not to be listed on Friday, your lordship.
Next Friday
This Friday.
for hearing.
For hearing.
Okay.
For hearing. For hearing.
One is for orders, your lordship, and other is for hearing. Everything is ready. Culture is turned up. Most urgent.
For orders item on 25th and hearing in the last week of November.
Mm.
If possible, in
Then hearing in the first week of November, 7th November.
7th, my senior will not be available. Before Diwali, any day, maybe
How many
Diwali.
oh,
cases
barely not
lodged?
possible.
How can it be? On 7th November. The hearing is on 7th November.
Right.
Wait, please, your lordship.
Yes.
I filed this civil revision petition yesterday, my lord.
Hmm.
There's some urgency. My DW has been closed. My
Hmm.
lord, next date is fixed on 28th.
For
Lord, for orders, my lord, there is an IA also.
Hmm.
If your lordship can kindly take it up on Friday, my lord.
Okay.
Deeply.
Thank you, please, your lordship. Lordship, I beg to mention for listing one MFA. It's a old pending matter in the year of 2017. Lordship, matter may be fixed on 26th of November.
For hearing,
Hearing
hearing matter.
26th of November.
Okay.
Like your lordship.
Yes, your lordship. That's a prayer for listing. IS 127, lordship. I'm
What?
catching my breath.
for
One,
condonation of delay.
no, lordship, listing.
This thing.
Yes.
Okay.
Okay.
When do you want?
2810.
28. Items for admission, item number 1.
May it pleases your lordship. Your lordship, this revision petition has been filed challenging the order passed in the mistake case number 89 of 2022, passed by the Court of Civil Judge at Borpeta, by which it was held that the suit itself is barred by res judicata, and consequently, because of this order, the suit has been dismissed. The title suit number 56 of 2022. What has happened, the petitioner has, as plaintiff, has filed a suit seeking declaration of his right title interest for recovery of possession and permanent injunction. As against that, the opposite parties, they filed their written statement, and along with the written statement, they filed a petition which was registered as Misja case 89 of 2022, stating therein that this petition is under section 11, read with section 151 of the CPC, and they have sought for dismissal of the entire suit on the basis that the suit is barred by res judicata. And objections were filed. The learned trial court, after hearing both parties and after perusing the petition, passed the order, allowed the petition And as such, consequently, the suit was also dismissed. So this petition has been preferred challenging and exceeding that order dated 22/5/2023 on the grounds that, number one, that the question of res judicata is a mixed question of law and fact. Now, without taking evidence as such, even without framing an issue with respect to that of res judicata, the court could not have entertained this petition and allowed this petition and dismissed my suit. Now, res judicata does not strike at the root of the jurisdiction of any court. Like the jurisdiction bar may be on the basis of pecuniary jurisdiction, it may be on the basis of territorial jurisdiction. But res judicata as such does not create an embargo not to file another suit. Of course, the trial court ought to have either framed a preliminary issue and decided on the basis of that the point of res judicata, because ultimately evidence has to be taken. Or it would have decided the point of res judicata finally during the trial of the suit. Without resorting to any of those two options, it has directly on the basis of a petition which is not accompanied by any document, has allowed that petition and held that the subsequent suit, that is, it is a subsequent suit and that it is barred by section 11 of the CPC as barred by res judicata. Allowed the impugn order is annexure 5. It is at page number 34. Starts at page number 34. Kindly peruse 35, page number 35, last para. This court has perused the case record of title suit 56 of 2022, earlier numbered as TS so and so before the London Munsif number 1 Borpeta, and also perused the plain written statement of title suit number 107 of 2001. Copy of the order dated 3/10/2005, passed in title Appeal 2 of 2004. On perusal of the same, it appears to this court that the predecessor in interest of the present opposite parties plaintiffs, namely late Abdul Aziz Elias Abdul Rahman, along with plaintiff Hazrat Ali Abdul Karim Abdul Ghani, Piara Nessa and Dujjan Nessa had filed title suit 107 of 2001. They are the legal heirs of late Rahimuddin. The present opposite party are grandson of late Rahimuddin and sons of late Abdul Aziz Elias Abdul Rahman, who was one of the plaintiff in the suit in title suit 107 of 2001. The suit TS 107/2001 was filed for declaration of right, title, interest and possession in favor of legal heirs of Rahimuddin as mentioned above over Schedule A land, which is 10 bigha 8 lessa under Dag 800, Dag 801 and Dag 819 of village Bongogi, Moza, Titapani, Borpeta. Khas position of Schedule B land was also sought for by the plaintiffs in TS 107 of 2001 for 2 kathas of land under Dag number 801 out of A schedule land covered by periodic patta 66. The said suit TS 107/2001 after contested trial was dismissed in favor of the petitioner's defendants, white judgment and order dated 12/12/2003. When the predecessor in interest of plaintiffs preferred title appeal 2 of 2004 before this court, that appeal was dismissed as appellants did not take steps and were not interested to proceed white order dated 3/10/2005. The judgment in TS 107 of 2005 decided all the issues of right, title and interest of predecessor in interest of plaintiff Abdul Aziz Elias Abdul Rahman along with others and held under discussions under issue number 3 whether plaintiffs have right, title, interest and possession over A schedule land. The issue number 3 was decided in the negative and learned court found that plaintiffs, that is the predecessor in interest of the opposite party, plaintiff's father Abdul Aziz Elias Abdul Rahman along with others have no right, title and interest and possession over the schedule A land. That is 10 bighas, 8 lessas of Dag 800, 801 and 819 of periodic patta number 66 of village Bongogi. The issue of law of limitation was also decided against the plaintiffs stroke opposite parties. That law of limitation bars the filing of the suit. Khas possession was also denied as it could not be proved. In the present suit, the sons of late Abdul Aziz Elias Abdul Rahman, that is opposite parties, stroke plaintiffs Azizul Haq and Azibur Rahman filed the suit for declaration of right, title and interest over schedule suit land 10 bigha 8 lessa of DAG 800, DAG 801, DAG 819 under periodic Fatta number 66, which is the same suit land of title suit 107 of 2001. Though opposite party stroke plaintiffs sought for recovery of possession, same is not mentioned in the schedule as to how much land has been dispossessed and how much land opposite party has sought for declaring their right title and interest, as there appears to be other legal heirs of late Rahimuddin Sheikh. Accordingly, it is found by this court that the issues which were raised in the present suit, title suit 56 of 2022, are already decided in title suit 107/2001 by the Court of Competent Jurisdiction of Learned Munsif number 1, Balpeta, White Judgment and Decree dated 12/2003. Here I would pause for a moment. Lordship, this petition was decided when no issues were framed by the court itself. So the court, without framing any issue, has found that the issues which were raised in the present suit in title suit 56 of 2022 are already decided in title suit 107 of 2001. So I'm continuing. The judgment has discussed in details all the issues, and since that judgment has attained finality, against which though appeal was preferred by title appeal 2 of 2004, and that was not continued, for which title appeal 2 of 2004 was also dismissed, the opposite party plaintiffs are barred under the principles of res judicata under section 11 CPC from raising the same issues which are already heard and finally decided by the learned Munsif number 1 Balpeta. Opposite party stroke plaintiff has not come with clear hands and has abused the process of the courts by filing title suit 56 of 2022 by showing wrong cause of action, and for that also the title suit TS 56 of 2022 needs to be dismissed as per law. Accordingly, in view of the above discussion, the petition 213/2022 filed by the petitioner defendants is allowed, and the title suit 56 of 2022 is dismissed as hit by the principles of res judicata under section 11 CPC. With the above, title suit 56 of 2022 is dismissed, and the Ms. J case number 89/2022 is allowed on contest in the light of the above order. So all these findings have been arrived at only on the basis of a petition that has been filed before the court. No evidence, nothing. Neither the judgment of the trial court was exhibited before the court, nor the issues that were framed in the previous suit, nor even the plain as well as the written statement were exhibited. So without going the evidence part directly on the basis of a petition, on the mere allegation that earlier suit was filed by the predecessor in interest.
No,
My
perhaps the judgments in both the cases were produced before the court.
No, only the titleable judgment was produced. Only the
Yes.
titleable. And my lord will file their petition.
No. I am asking him something. Yes.
Lordship may kindly revisit the order, Lordship. Again, Lordship. The 11th portion, Lordship, at page 35, Lordship.
Hmm.
The last paragraph, Lordship.
Hmm.
The court has perused the case records of title suit 56 of 2022, earlier numbered as TS 401 of 2021. This is the present suit, Lordship, present claim, Lordship.
Hmm.
And also peruse the plain written statement of TS 107 of 2001.
Hmm.
A copy of the order dated 3/10/2005 passed in title appeal number 02 of 2024.
Hmm.
2004. So, Lordship, this clearly shows that the written statement, plain, title suit, judgment, and title appeal
Hmm.
all were placed before the court, and the court has perused and considered the judgment, Lordship.
Hmm.
Everything materials were, though they were not exhibited, but the duty of the court is to examine the records. And the learned court below has examined the records and find that their predecessors in interest, Lordship, the next 2-3 lines, Lordship.
Hmm.
The predecessors in interest of the present opposite parties, plaintiffs, namely late Abdul Aziz, alias Abdul Rahman, who is the father of the present petitioners, Lordship, along with the plaintiff Hazrat Ali, Abdul Karim, Abdul Ghani, Pirana Nessa, and Dujjan Nessa had filed title suit 107 of 2001. They are the legal heirs of the late Rahimuddin.
Hmm.
And the present opposite parties are grandson of late Rahimuddin. and sons of late Abdul Aziz alias Abdul Rahman, who are one of the plaintiff in the suit in title suit number 107 of 2001. The title suit 107/2001 was filed for declaration of right, title, interest, and possession of in favor of the legal heirs of Rahimuddin. The same issue here before Lordship in this case also. And Lordship, as mentioned above, the Schedule A land, which is 10 bigha, 0 katha, 8 lesa under that number 8 so and so so and so. Same cause of action, same title, seeking same title of the or same plot of land, and that has been learned court has below recorded this judgment on examination of the all records, Lordship. This is not required that they have to be exhibited. And Lordship, under Order 7, Lordship, your Lordship knows that in the preliminary stage also the court can dismiss a case if it is barred by law. And the section 11 and 12, if we read combinedly, then there is absolute bar on the principle of res judicata, Lordship. And the
No,
original.
can it be decided without framing any issue, whether preliminary or final?
Yes, Lordship, because the Lordship this learned court below has in the last paragraph has mentioned that the opposite party plaintiff has not come with clear hands. They have not even mentioned about the title suit number 2007 and the title appeal subsequently they filed in 2004, Lordship. Title suit number 107 of 2001 and title appeal number 2 of 2004. They have not even mentioned in their plain Lordship. So they have not come.
Title appeal number?
Not by the plaintiff, Lordship, the present petitioners, Lordship.
No, title appeal number?
Title appeal number 02 of 2004, which the learned court below has perused, Lordship. And the title suit number 107 of 2001. They even have there is no whisper even, Lordship, regarding this title suit and title appeal. And the parties are same. And we the present respondents, who are the defendants, have produced the all original in their court, Lordship. And the Xerox copy is with me, Lordship, but the original copies are before the learned court below. And after perusing the original records, Lordship, thereafter they decided this issue. And the Lordship, aim of the section 11 and 12 is also that there should not be any abuse of process, Lordship. And the same issue should not be again revisited by the court, Lordship. And the same party should not be again prosecuted on the same subject matter, Lordship.
Okay.
This is
Yes.
my main
My
point.
lord, the first submission is totally incorrect.
Mm.
It is, here it reads as that the court has perused the case record of title suit 56 of 2022, that is the present suit, and also perused the plain and written statement of title suit 107 of 2001, that is of the previous suit, copy of order dated 3/10/2005, passed in title appeal 2 of 2004. So the court has not perused the judgment of the trial court. That is in title suit number 107 of 2001. It is very clear here. It has only perused with regard to judgment. It has only perused the judgment of the first appellate court. And secondly, it is submitted that the original have been perused. Nowhere it has been mentioned that the original case record has been produced before the court and it has been perused, because the original would be somewhere in the record room and there is a process for that, and that would have found mentioned in the order itself. So only seeing the Xerox copies of certain orders, the court without framing an issue cannot decide that. And moreover, Order 7 Rule 11, Order 7 Rule 11 is for rejection of the plaint. This is not an application under Order 7 Rule 11 for rejection of the plaint. Neither the plaint was rejected. Outrightly, the miscase was allowed and it was dismissed. Suit was dismissed. And Order 7 Rule 11 D, which says that a plaint may be rejected when it is barred by any express provision of law. That res judicata does not come under that. I will place before the court some judgments of one of this honorable court and others of the apex court. Very similar one case that was decided by this honorable court only, the first one. Anil Majumdar, the first judgment, Anil Majumdar. Kindly come to para 2 first. This revision petition has been preferred against the order dated so and so, passed by the learned Munsif number 2, Kamrup at Guwahati in miscase number so and so arising out of the title suit number so and so, thereby dismissing the suit filed by the petitioner plaintiff, holding the same to be barred by res judicata as per provision of section 11 of the CPC. Exactly our case. So I'm relying upon paragraph number 7 on the next page. I have considered the submissions made by learned counsel for the petitioner and have also perused the records. The question as to whether a suit is barred by principles of res judicata or not is a mixed question of law and fact, which has to be decided by the trial court at the stage of trial. In the instant case, the trial of the suit was yet to commence. The written statement filed by the defendants was not apparently taken on record. Under such circumstances, the learned trial court was not right in law in dismissing the suit, holding the same to be barred by res
No,
judicata.
in our case, the written statement was filed.
The written statement was filed.
Yes.
But here it is said that it has to be decided at the stage of the
That-
trial. Trial doesn't start when written statement is filed. Trial starts when evidence starts.
Hmm.
At least after the framing of the issue in a civil suit. So issues were not framed. So trial has not commenced. That apart, the impugned judgment order dated also does not record any finding of fact to the effect that the suit line involved in the former suit was one and the same
No,
involved in
in
the
the case
subsequent
in
suit.
hand, it is recorded in the order.
It was recorded on the basis of the allegations that was made in the petition.
Now you come to the next judgment.
Next judgment, I am relying paragraph number 11, 12, 13 and 15. This is V. Rajeshwari. 11, the 11 at page 4, internal page 4, the rule of res judicata does not strike at the root of the jurisdiction of the court trying the subsequent suit. It is a rule of estoppel by judgment based on the public policy that there should be a finality to litigation and no one should be vexed twice for the same cause. 12, the plea of res judicata is founded on proof of certain facts and then by applying the law to the facts so found. It is therefore necessary that the foundation of the plea must be laid in the pleadings and then an issue must be framed and tried. This is most important. And then I'm relying upon paragraph 13. Not only the plea has to be taken, it has to be substantiated by producing the copies of the pleadings, issues, and judgment in the previous case. Maybe in a given case, only a copy of judgment in the previous suit is filed in proof of plea of res judicata, and the judgment contains exhaustive or in requisite details the statement of pleadings and the issues which may be taken as enough proof. But as pointed out in so and so, the basic method to decide the question of res judicata is to determine the case of the parties as put forward in their respective pleadings of their previous suit, and then to find out as to what has been decided by the judgment which operates as res judicata. It is risky to speculate about the pleadings merely by a summary of recitals of the allegations made in the pleadings mentioned in the judgment. The Constitution bench in Gurvak Singh versus Bhuralal, placing on a part the plea of res judicata and the plea of estoppel under Order 2, Rule 2 of the CPC, held that proof of the plaint in the previous suit, which is said to create the bar, ought to be brought on record. The plea is basically founded on the identity of the cause of action in the two suits, and therefore it is necessary for the defense which raises the bar to establish the cause of action in the previous suit. In many words, it is said proof, established. So how that can be done without taking evidence? Then I'm relying upon next one, that is Sri Hari Hanumandas Totala. Here only I'm relying upon limited portion, paragraph number 20. This is under Order 7, Rule 11, what has been submitted from the other side, that is Order 7, Rule 11. So it is deciding Order 7, Rule 11D on the basis of res judicata. Para 20, subclause 3. To determine whether a suit is barred by res judicata, it is necessary that the previous suit is decided, the issues in the subsequent suit were directly and substantially in issue in the former suit. The former suit was between the same parties or parties through whom they claim litigating under the same title, and that these issues were adjudicated and finally decided by a court competent to try the subsequent suit. And 4, since an adjudication of the plea of res judicata requires consideration of the pleadings, issues, and decision in the previous suit, such a plea will be beyond the scope of Order 7, Rule 11D, where only the statements in the plain will have to be perused. So this settles the Order 7, Rule 11, and then next judgment, that is Kamala and others, para 23. The principles of res judicata, when attracted, would bar another suit in view of Section 12
Which
of the
paragraph you were reading?
23, para 23, internal page 669. The principles of res judicata, when attracted, would bar another suit in view of Section 12 of the Code. The question involving a mixed question of law and fact, which may require not only examination of the plaintiff, but also other evidence, and the order passed in the earlier suit may be taken up either as a preliminary issue or at the final hearing. But the said question cannot be determined at that stage. So at Order 7, Rule 11 stage, it cannot be decided. And last judgment, Satyanath and another, I am relying upon para 31. Para 31, I will not read the whole para, only the last line that is relevant, that is the ratio. It is not disputed that res judicata is a mixed question of law and fact, depending upon the pleadings of the parties to the suit, etc. It is not a plea in law alone, or which bars the jurisdiction of the court, or is a statutory bar under clause B of sub-rule 2. So it is not a statutory bar, but neither it is a jurisdictional bar. It has to be proved. Res judicata has to be proved, and for proof, evidence has to be laid. For laying evidence, issues have to be framed. Then the comparison comes whether these issues have already been decided in the previous suit or not. Simply deciding a petition that these matters have already been decided and these parties are no one but successor in interest of the previous parties.
No,
Court cannot
is
come
it, is it not possible to decide the issue on the basis of pleadings of the parties, the judgments?
Yes.
Delivered already, and also the issues framed therein?
The issues have to be framed and evidence has to be taken.
Hmm.
On that, if a preliminary
No,
issue is
if
framed,
say, in the present case, one petition has been filed.
Hmm.
On that, on the basis of that petition, the miscase was registered. And both the parties were heard. And in the said petition, all the judgments and orders passed earlier were produced. And thereafter, the court arrived at a conclusion that it is barred by the principle of res judicata.
that would not lie because that would be countered by the first judgment itself.
Hmm.
And also it cannot be decided without taking into evidence. Those judgment,
No,
copies
you
of
tell
judgment
me
have to be
this
created.
first judgment you have relied upon, can it be read as a precedent? Whether any principle of law is laid down herein?
The question, yes, the 7, para
Hmm.
7, the question as to whether the suit is barred by the principle is a mixed question of law and fact,
Hmm.
which is to be decided by the trial court at the stage of the trial. So
Hmm.
let the trial commence. At least the trial court, if it found necessary, could have framed a preliminary issue as to whether the suit is barred by res judicata, and then ask the parties to lay the evidence on that limited issue and then decide it there.
Hmm.
But here that has not been decided.
No,
No evidence
though-
on record, no issue.
Though no preliminary issue has been decided, one petition has been filed
Fine,
on that ground. On the basis of which this miscase has been registered,
registered.
both the parties were heard,
Fine.
relevant documents were produced, including the judgments.
It is not a case that lordship only he has taken a plea in the written statement.
My lord, kindly
It has
come to page number 21. That is their petition. Page number 29 and Lecture 3. I will not read the full petition. Kindly peruse. There are no annexures here. There are no annexures in this petition. So in which manner they could submit copies of the judgment of the appellate court as well as plain and written statement. There is no mention of nothing here.
Hmm.
And this petition was allowed.
But as per the impugn order, the same were produced before the court.
But how they are produced, that was not explained. But here nothing is annexed. So who produced it?
Hmm.
Specific
The
mention of
petitioner did not produce it. That means because there is no annexure, nothing. Nowhere it is stated that we are enclosing the copies of the
No,
plain.
does it mean that the court itself has procured the same?
maybe,
maybe.
or maybe copies,
No,
copies
no,
of
no.
the judgment have been supplied later on. Because the petition, it doesn't find any mention,
Hmm.
no documents have been enclosed, no documents have been annexed. Simply a petition has been filed.
Humble submission is the lordship, there is no requirement of specific mention of annexer in the written statement or petition lordship. If he produced and the learned court has taken consideration, that's enough. And lordship, the learned
At
failed,
least
but
certified copies ought to have been produced. These are not, even certified word is not there in the impugned order.
then
It
lordship.
doesn't say that certified
Call
copies. I
for
produced the
record,
certified
lordship, then lordship can examine whether the certified copies were produced or not. Whether or Xerox copy were produced. Lordship can then call for records and examine.
And the greatest lacuna remains that the judgment of the trial court has not been perused.
Okay, let the record come then.
Yes, ma'am.
Not.
Both the parties are represented by the. Having heard the submission of learned advocates of both sides, perusal of the original record is found to be necessary, and accordingly it is provided that recessal call for the original record from the learned trial court. List the matter after 2 weeks.
Deeply obliged.
Item number 2,
What page, Your Lordship? Hello, this is an appeal filed by the insurance company, Lordship.
Hmm.
Against the judgment passed by the learned tribunal, Kamrup Lordship, 25/7/22. Mainly on the ground that Lordship, the driver who drove the motorcycle, Lordship. He was the owner cum driver, Lordship, had a fake driving license at the time of accident. And Lordship, the secondly, the income was accepted as 6,000, though it's a minor girl, Lordship. And the interest on future prospect is illegally imposed, Lordship. These are the grounds, Lordship. And this is in statutory appeal, Lordship may admit the appeal and stay may be granted, Lordship.
They may be granted subject to payment of 50%.
50%. Okay.
Okay, that
Heard,
Lordship,
Miss,
furnishing an indemnity.
M.
bond, Lordship.
Sodori, learned counsel for the appellant, and also heard Mr.
Each of them.
D. Sodori, learned counsel for the
Respondent
respondent
number
number
1 and 2.
1 and 2. And for respondent number 3,
Lordship, it is.
respondent number 3 is so and so, learned counsel for the respondent number 3. This appeal under section 173 of the MBH is directed against the judgment and award dated 25/7/2022 passed by the learned member Motor Accident Claim Tribunal, Intermediate MSCT, number 1, Kamrup and Assam, in MSC case number 835 of 2017. This has been noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees 13,08,600, being the compensation to the respondent number 1, 2, and 3.
1 and 2.
Lordship,
1 and 2.
these are the
1 and
claims,
2.
Lordship.
1 and 2. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated so and so. Admit. Issue notice. However, no formal notice is required to be issued as both the parties, no, as respondent number 1, 2, and 3 by their MB's counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. Rest shall call for the record from the learned member MSCT, Kamrup and Guwahati. List the matter after 4 weeks. Who is IA you have preferred for staying?
Lordship, this is IA number 2512. Furnish a copy to you.
Okay. it will per-
Lordship,
Subject to payment of 50% of the awarded.
furnishing a indemnity bond, Lordship. And I will serve a copy to the number 3, Lordship, respondent number 3. He has appeared.
Okay.
Is supposed to deposit 50% lordship, not indemnity bond.
Furnishing an 50%, Lordship, and
Uh-huh.
subject to furnishing of an indemnity bond, Lordship. As because we have disputed, there is a breach of policy conditions.
Within a period of 2 weeks,
Because we have to obtain the 6 weeks, Lordship.
6
6
weeks.
weeks.
No.
4 weeks then, Lordship.
No, 3 weeks.
Weeks.
3 weeks. And subject to furnishing of an indemnity bond, the respondent number 1 and 2 may be allowed to withdraw the aforesaid amount on filing a petition before the registry of disbursement.
My senior Mr. Gayabra name may be reflected in that form.
His name,
Name.
okay, okay. The name of Mr. So shall be reflected in the cause list.
Most obliged, Lordship.
Item number 3, matter for orders.
Lordship, I appear on behalf of the respondents in this case, Lordship. So I may be allowed at least 3 weeks time to file our affidavit in.
Heard, Mr. Your good name?
Edas.
Learned counsel for the petitioner. Mr. Your good name?
T Das,
He does learned counsel appear on behalf of,
respondent,
appearing on behalf of respondent number
1 and 2.
Respondent number 1 and 2 submits that he may be granted at least 3 weeks time to file his objection. Period is accordingly allowed. Recessal is the matter after 3 weeks.
3 weeks, Lordship.
How many respondents are there?
2 respondents, Lordship.
Only. Okay. You have filed Ukalatnama?
Today we will file it. Within 1 hour, I will file it, Lordship.
You have
Because they have
filed.
engaged yesterday, Lordship.
Acha. The learned counsel for the respondent number 1 and 2 submits that he has submitted his Ukalatnama only today. Rest shall reflect his name in the cause list.
Always.
Item number 4,
Your Lordship, I was filed for condemnation of delay of 122 days. This was taken from orders.
Madam, you are for respondent number?
1, Lordship.
Respondent number 1.
Full respondent.
Full respondent.
Full respondent.
Answer. Any objection in condoning the delay?
Lordship, delay is of 122 days. But the main appeal is filed against the ex parte order and decree, Lordship, which is devoid of merit. The devoid of merit means there was a case for guardianship filed by the mother of the child. Guardianship certificate. And that case was had ex parte. Beyond service of notice, they did not appear in the case. So now they have come for this appeal against that order and guardianship certificate.
No, we will hear you on merit in the main petition. But in this petition, do you have any objection in condoning the delay?
Delay is of 122 days, Lordship. It's up to your Lordship.
You have no objection.
Actually, there in the main petition.
Okay. Pardon me, your good name?
S. Jain Hayat.
S. Zain Hayat, learned counsel for the applicant, and Madam
Okay, Amen.
S. A. Ahmed, learned counsel for the respondent. This application under Section 5 of the Limitation Act is preferred for condonation of delay of 122 days in preferring the FAO against the ex parte decree and order dated 3/10/2023 passed in Ms. Z case number 8 of 2022 passed by the learned district judge Sibsagar. And the guardianship certificate dated 9/11/2023 granted by the learned district judge Sibsagar. So why you could not file the appeal in time?
Lordship,
Why you could not file the appeal in time?
file the appeal in time, Your Lordship, because the case number AW22 was declared ex parte, and I came to know about the ex parte order only after I filed a similar case, guardianship case, in before the Larded Family Court, Kamrup. When we served notice upon the respondent and the respondent appeared, then only I come to know that she has already earned a decree by filing a similar case in 2022. And after coming to know
In
that,
which paragraph of your application you have explained the reason?
in the IA, Your Lordship,
Yes.
Your Lordship, in paragraph number, Your Lordship, in page number 12, page number 10, 11, 12. And 9 also.
Page number 10, 11.
8, 9, 10, 11. Your Lordship, paragraph number 10. Of page number 8.
The learned counsel for the applicant submits that the applicant was not aware of passing of the ex parte order in Miss Z case number 8 of 2022, passed by the learned district judge Shivsagar, and he came to know about the same only when he filed one application before the learned principal judge family court number 1 Kamrup Guwahati on 20th 10/2023 in Miss Z case number 163 of 2022. And that the delay is not intentional, and the same has been sufficiently explained in paragraph number 10. Paragraph number 10, and therefore it is contented to condone the delay of 122 days in filing the FAO. The learned counsel for the respondent submits that she has no objection in condoning the delay. But having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents placed on record, especially paragraph number 10 of the application. It appears that the delay of 122 days sufficiently explained in this petition. And having been satisfied, this court is inclined to condone the delay of 122 days in filing the connected FAO. In terms of above, this FAO stands disposal. In view of order passed in IA number 1451 of 2024, now the registrar shall register the FAO and place the same and list the same before the court.
Item number 23.
Also, please.
Next legal also. Lordship, this is a delay condemnation application, but the last office note says that neither the unserved notice nor the AD card is returned back. My lord, it may be deemed to be served, my lord, because 30 days have already expired. And,
But, have you have taken a step by registered post,
yes.
registered post,
Both ways.
both way?
Both.
Have you tracked the consignment in the website?
I have not checked, my lord. I'll have to take the number and then.
Whether the number is available in the record?
I have to check, my lord.
You check it, we will take it up at 2 o'clock today.
24,
May I please your lordship? Lordship, as per office note dated 21/10/24, steps for the RSA is completed. But for the IA, the service is awaited. Service report is awaited, my lord. We have already taken steps, lord.
That's all right, let the report come.
My lord, also, in the IA, the names of the pro forma respondents may be struck off. They are not a necessary party in the IA.
Then why you have implemented them?
Due to some inadvertent errors from our side, my lord.
How many performer respondents are there?
4 respondents.
4.
Yes, my lord.
Pardon me, your good name?
J. Sharma,
Learned counsel for the applicant. Office note dated 21/10/2024 indicates that service report upon the respondents are still awaited. Recessal is the matter after 2 weeks awaiting service report upon the respondents. Learned counsel for the applicant submits that the name of respondent number 8, 9, 10, and 11 who are performer respondents in this application may be struck off as they are implemented as performer respondent inadvertently. Here, having considered the submission of learned counsel for the applicant, it is provided that the name of the respondent number 8, 9, 10, and 11 may be struck off at the risks and cost of the learned counsel for the applicant. Let's the matter after 2 weeks.
deeply obliged.
items for hearing. Item number 6,
It pleases your lordship. Lordship, I am appearing on behalf of Mr. S.P. Chaudhary for respondent number 1, lordship. Lordship, today he is having some personal difficulty. Lordship, can it be adjourned for the day, lordship? Last time
This is of
also they-
2011 matter.
Last time also they did that, lordship. Last time they said he is in some other court and the matter is very old. And I come prepared reading all the judgments and all, lordship. It's difficult. They could have informed me. I wouldn't have objected had they informed me last night. Because I come prepared. Let it be tomorrow or Thursday, lordship. Yes, lordship. A short date may be given. Short date was just before holidays. It was short date. That's why it came today. And again, short date, lordship.
Okay,
Did lordship, how November first week, already so many cases. On 12 November, we'll try.
Okay, lordship.
Well,
They
well,
should try.
on
They
the
should
share being
try.
made by Ms.
B. Devi, lordship. On behalf of
BW
Mr.
Learned
S.P.
Counsel appearing on behalf of Mr. S.P. Chaudhary.
Yes, lordship.
Learned counsel for the petitioner. No, respondent having not been objected by Ms. Ardas Learned counsel for the appellant. This is the matter on
12 November.
12th November. On that day, an attempt will be made to finally hear and dispose of the matter. It is further provided that no further adjournment will be granted.
To the respondent. I might have some issue, lordship, with the respondent.
Okay.
Item number
Highly
9,
obliged, lordship.
sorry, item number 8. Item number 8,
Lordship, similar prayer for this item also.
Last time, nobody appeared, my lord. Your lordship may just take up, my lord. Again, my lord, this is a matter of 2015. And the decree is being stayed, my lord. I mean,
Suggest a short date What to do if the council is absent?
14 November. You can try on 14th.
My lord, it may be on 29th, my lord.
Before vacation, not possible.
No.
Diwali, after Diwali.
14 November.
Lot of matters have been fixed.
14 November.
14 November. Okay.
Maybe then, my lord, no adjournment, my lord.
Okay, same order.
Briefly, okay.
Item 9.
If here I have filed an IA lordship. Under order 41 rule 27 lordship for additional evidence lordship. If lordship, I don't know if my learned friend is me appearing. If he has to say anything lordship is rebuttal lordship. He may file otherwise lordship. If decide lordship if any other past lordship in this IA, that should be heard along with the RSA lordship. Because what happened, lordship, during the RSA lordship, this evidence I could not appear give before the trial court lordship and the appellate authority also. But during the pendency of the RSA lordship, I have filed RTI lordship.
Have you received the copy of this IA?
Lordship, I have received the copy.
You have received?
But he has filed an IA under order 41 rule 27, Lordship. There is a rules of practice, Lordship. This IA has to be heard at the time of final hearing of this appeal, this instant appeal. It cannot be heard or decided before the final hearing of the appeal. So, my humble submission before our Lordship, the appeal may be heard. If Lordship finds it necessary that without allowing the IA or without the documents that has been sought to be recorded, sought to be furnished to this appeal, if Lordship finds that without that record, Lordship cannot pass any judgment, then only in that event, Lordship can
IA
decide,
can be allowed.
decide the IA. Otherwise, Lordship, now before that, before hearing, final hearing, Lordship, that IA need not be decided.
Are you ready for
So,
hearing?
lordship, if it may, in this case, my senior will argue this matter, lordship. If he is ready, then lordship, this point, lordship, day after tomorrow, lordship, then I, along with the IA, lordship.
Day after tomorrow.
Day after tomorrow, lordship. Yes,
Lordship,
I'm ready.
Lordship, this appeal, Lordship, listed after early hearing petition. After I filed the early hearing petition and that early hearing petition was allowed.
I am not objecting, lordship.
Giving me
2016
giving me liberty to mention for upgradation, Lordship. And last several occasions, my learned brother has taken already time.
No,
So
lordship.
this time
I
also,
am not taking,
Lordship,
lordship. Only one time, lordship, for filing IA, lordship. How, this is wrong, lordship. The senior advocate or Tijam will appear, lordship, then day after tomorrow, lordship. Tomorrow, not lordship, day after tomorrow. Is ready, otherwise I was supposed to, lordship, he will object or not, lordship, but regarding the IA, if IA is heard today, I have
the
to
case
place.
of my learned brother should be ready first.
Okay, day after tomorrow then.
Lordship,
As agreed by learned advocates about the parties, rest is the matter day after tomorrow.
Lordship, with the
On that
observation,
day, this IA file, IA number 2918 filed by the appellant shall also be considered.
lordship.
no adjournment will be considered.
Okay.
Okay.
Item number 10.
Lordship, I was not available. I was in village for a long time. Let the matter come after some time.
After?
It is 2016-17 matters. Second appeals are being listed for 2013-14 now.
So you are not ready today?
Today I am not.
Yes, Mr. Day?
Next Tuesday, my
Next Tuesday.
Tuesday.
Okay, possible.
Or
Only in second week of November. Second week of November. Lot of cases have.
my lord, a date may be fixed, my lord.
Okay.
My lord.
As agreed by learned advocates about the parties, rest shall list the matter on
On 14th November.
14 November. It is further provided that no adjournment will be granted.
Item number 11.
The main prayer, my lord, 14th November, I have some problem. 12th November, is it possible? 12th November.
But whether it will be convenient
I
to
will,
him or not.
yes, 12th November.
Yes, Mr. Talukdar.
My lord, this is an appeal. The 173, my lord. The impugn order is, my lord, the claimant has filed the claim application before the learned court claim tribunal. The claimant's counsel could not appear before the trial court on the ground that the case was not listed in the cause list. In the trial court, the case list is there. In 6 consecutive days, my lord, the case was listed. The counsel of the claimant was not appeared, and that is why the case was passed. The order was passed on merit, my lord,
Without hearing the parties.
without hearing the parties. So my only prayer is to remand the matter and an opportunity, because their son already expired out of the accident, motor vehicle accident. So at least an opportunity may be given. Madam.
Where is the order?
Where is, my lord, order is page 20. Court has framed issue unilaterally.
But the name of one counsel is reflected in the judgment, Mr. A. Salam.
Yes, his name was reflected.
Find the evidence also, it is mentioned in paragraph 6 of the judgment.
Madam?
They
Come
did,
this way.
oh, sorry. Paragraph 6 of the judgment, the court has given a full judgment, Lordship. It is not an order. 6, they filed their affidavit also. Evidence in affidavit, they did not appear.
Claimant.
Yes, paragraph 6, it is mentioned. From the initial date for filing evidence in affidavit, the claimant as well as learned counsel for the claimant side, they did not appear from the time the evidence was remained absent for 6 consecutive days without any steps. As such, the petition filed on demand by the learned counsel is rejected, presuming that the petition has been filed to further lingering the case and judgment in delivered. And this mention about our High Court judgment that a case cannot be dismissed for default, Lordship, MSC case. It has to be decided as per the, so the court has decided the issues.
No, it amounts to same.
It amounts the same, my lord.
No, Lordship, but that judgment, Lordship, which our High Court gave, that was for dismiss for default. Here, Lordship, it is not there. The court has decided the issues that they
But
failed
no,
to.
without hearing the other side, it amounts to
It
same.
amounts the same.
But that is not the same, Lordship.
How?
Because dismiss for default,
Hmm.
there the parties did not appear.
Mm.
So, yeah, Lordship is saying that the court has mentioned that they did not appear. So, deciding the case,
Mm.
but they filed a petition. That petition was rejected on that day.
Mm.
It is not a case of dismiss for default. On 16/5/2017, the day this order was passed, Lordship, that day they filed a petition. But in their memo of appeal, they say they did not know the date and the council did not know, but then they filed this petition, it's a petition on that day.
Mm.
In the memo of appeal, the grounds, Lordship, they're mentioning that the council did not know the date and it was not listed in the daily list
Those are the grounds, Lordship. The thing is, on 16/5/2017, also, they filed a petition that is reflected in the judgment itself at page 6, paragraph 6. The petition filed.
This petition, my lord, this petition was filed with a prayer for allowing the claimant to lead her evidence. But the same was rejected by the learned court below on the ground that it is a tactic for delaying the claim. And straight away dismiss the claim. In the Motor Vehicle Act, there is no provision for dismissing the claim petition. There is no provision. Even in our High Court, my learned colleague is also agreed with me. There is no such scope for dismissing the claim petition.
No, the court
At least a
itself has
notice should
mentioned
be
the
given to the claimant, my lord. Due to
No, the case itself is mentioned by the court, that citation, 2008, supply GLT 161.
yes, it was reflected in the order.
Memo of appeal, they are saying that they did not know the date, they did not, but they have filed the petition, they knew.
That is why.
But madam, see, this judgment was passed without hearing the other side, without hearing the claimant.
Not, Lordship, hearing will, when they adduce their evidence, then only cases like they are establishing their case. And they did not appear, that's what the paragraph 6 says, Lordship. And Lordship, the case is of 2015. They did not take step, they did not appear, they did not do, and like it is 24, 67, 24, 9 years, Lordship. Who is to bear the interest for all these 9 years? The insurance company is not at fault here, Lordship.
Or maybe that aspect may be considered by the court, trial court, while passing the final judgment. This
Lordship,
interest
but
part.
Lordship will mention that because in another case, of course, today I do not have that, Justice Silo gave that direction that interest is not to be given. That was mentioned by the Honorable High Court when the matter was remanded back. So, and accordingly, the trial court gave the interest from the.
Can you produce that judgment?
Not right now, tomorrow?
We will pass the order. You can give it, if possible, today itself or by tomorrow morning.
Today I'll try, Lordship. Tomorrow I can give hard copy, but today I can give the number. of our
Only citation
MSC.
will serve the purpose.
Uh,
We'll take it out.
Yes.
We'll pass the order. We'll remand the matter. Both the parties shall appear before the member, MSCT Nagaon, within a period of 2 weeks from today.
2 weeks. And Lordship, time frame that within 3 months or 6 months, the case is to be,
No, madam, there is a recent judgment of Supreme Court.
that it cannot be.
Cannot be.
The High Court cannot direct but
Cannot
endeavor,
frame. Right.
endeavor can be made.
Okay. We'll request the member to make an endeavor to dispose of the same as early as possible. To dispose of that.
Number 12.
May it please your Lordship. Lordship, this case in the during the interim order itself, in fact, the case was like the line of the case was taken. Here, Lordship, what happened? The order was given to pay and recover, Lordship. We challenge that. And by order dated in I 3149 of 17, by order dated 22/9/17, I number 3149 of 2017.
Yes.
We were directed to deposit 50%, but a direction at paragraph 4 was given to the tribunal that the release will not be made till security is given by the owner of the vehicle. Lordship, in the final 50% also, same thing can be done. We will be depositing the rest of the amount, rest 50%, and this is to be followed, Lordship. Otherwise, I'll go for the whole hearing part because there is not much. What we are challenging is that the pay and recovery should not be given, and if be given, it should be as per the Nanjappan judgment or Chala Bharatamma the security is to be given by the owner of the vehicle and it is to be released. So paragraph 4 of that IA lordship purely covers this case lordship. I don't think you have a.
We already 50% already released by the Honorable Court, and the owner of the vehicle has given an undertaking in compliance of the order of the Honorable Court, dated 22/9/2017.
No, this matter is for final hearing today.
Yes.
Final hearing also, lordship, our argument is that only.
Same argument.
Same argument. Because we are saying that if at all the insurance company has to give that security, insurance company should have the right to recover it, and for that the security is to be given. And court relied upon Chala Bharatama. I have brought Chala Bharatama. I have other judgments also, lordship, on this point only. But
Lakshminarayan also.
Lakshminarayan Dutt is for, no, it is not for this. This is for consumer cases or events. Otherwise, I can do the full reading and Chala Bharatama lordship, paragraph 13.
So what is your pair in this appeal then?
My grounds, lordship, are that, first of all, that there cannot be a pay and recovery, but still if a pay and recovery is given, the court has given us the right to pay and recover, lordship. That is the effective part. Page 17 of my memo of appeal and internal page 12 of the judgment, lordship. The second last paragraph. The insurer, that is the Oriental Insurance Company, is directed to make payment, and the insurer is liable to be reimbursed by the owner of for the compensation amount which the insurer is compelled to pay to the third party as per the award of this tribunal.
You are reading paragraph number?
There is no number of paragraph, lordship. Page 12, page 17 of my memo of appeal, 12, internal page 12 of the judgment, lordship. The third paragraph. Paragraph number is not there.
Okay.
The insurer, lordship, got it. The insurer, that is the Oriental Insurance Company Limited, is directed to make the payment, and the insurer is liable to be reimbursed by the owner for the compensation amount which the insurer is compelled to pay to the third party as per the award of this tribunal. After payment of the compensation amount by the insurance company will be entitled to recover the amount in the same manner as provided under section 147 of the MV Act as errors of land revenue. This was the direction, lordship. But we filed the appeal saying that if we do not get the security, lordship, it will be not possible to recover the amount from the owner of the vehicle.
In which paragraph in your memo of appeal you have mentioned
it? Ground A, then ground B, lordship, C also, lordship. D is that they have not made the driver a party, so that, lordship, for now we are not pressing that.
So we can dispose of the matter by directing the owner of the vehicle to furnish the security.
Yes.
That is your only
Yes,
submission.
that's why Lordship, that's why I mentioned about the interim order, Lordship.
Hmm.
Interim order, paragraph 4, clearly it is mentioned, actually, same way the appeal can be disposed of, Lordship. We will be depositing maybe within 6 weeks, Lordship. And
6 from today.
from today. And the tribunal will follow this. However, the appellant is directed to deposit 50% of the awarded sum before the jurisdiction tribunal, being MSC Tribunal Noga, within a period of 2 months. That was from today. However, the said amount shall not be released unless the learned MSC Tribunal Noga complies with the direction of this Honorable Supreme Court in the case of Chalabharatama and other Supra. As per the said direction, the learned tribunal is required to obtain adequate security from the owner and to cause attachment of the offending vehicle as part of the security to its satisfaction. Then it would be open for the learned MSC Tribunal Nogam to release the said 50% of the awarded amount and to also initiate steps for recovery of the said amount from the owner. And in Bharatama case also, Lordship, paragraph 13, that is the direction that was given by Apex Court.
But in the paragraph number 1, you have paragraph number A, you have challenged the entire order, entire judgment.
Yes, Lordship, we have challenged the entire judgment, but then that itself does not prove that liability, Lordship, as per the judgments. The liability at that time. But if this is a case of today, Lordship, this appeal, then I would say that we are not liable, totally not liable because of the amendment which came in the MV Act, Lordship.
No, the accident took place long back.
Yes.
That's why that's why I'm saying pay and recover. But if today I file a case against the order of pay and recover, Lordship, then I'm not going to say that I'll pay and recover because of the amendment. Like defense under section, the learned code below was not just in directing the appellant company to pay and recover the amount. Yes.
The same order was already passed by the learned court below in the last para, which already taken note by your lordship.
No, the court is saying about 147, but no security. We need a security, Lordship, because once we pay the amount, it is very difficult to recover. Insurance company is bogged down by that issue, Lordship, because here also it is compensation is of 47,30,386 plus interest. So how much it comes to, and if we cannot recover it, the security part. And tribunal followed this high court order as per my instruction, Lordship, followed this high court order, interim order, and they were allowed only after security was taken from the owner of the vehicle. I think it will not.
Okay, take down. Heard Ms. R.D. Mazumdar, learned counsel for the appellant. Then also heard Mr. Talukdar, learned counsel for the respondent. This appeal under section 173 of the MV Act is directed against the judgment and award dated 5/8/2015 passed by the learned member MSC Noga in MSC case number 349 of 2012. This to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein, that is Oriental Insurance Company Limited, to pay a sum of rupees 47,29,386 rupees.
No, 30,300. 1,000 was for the cost.
Pardon?
The amount was 47,30,000. 1,000 was added as cost of procedure.
No, total amount is no, award is only that's 47,29,386.
Then down below, Lordship, the
so-
claimant shall also be entitled.
Okay, we will mention it.
Okay.
Within a period of 3 months from the date of judgment, and further directed that in the event of failing to make payment of the amount within the stipulated period, the amount shall carry interest at the rate of rupees 5% per annum from the date of passing the judgment, and further impose the cost of rupees 1,000 being the cost of the proceeding. The learned counsel for the appellant submits that the appellant is aggrieved by the aforesaid judgment and award as the learned member MSCT has directed to pay and recover the aforesaid amount as provided in the manner provided under Section 174 of the MB Act 1988 without directing the owner of the vehicle to furnish any security, and that while filing the appeal before this court, one IA being IA number 3149 of 2017 was filed. To stay the execution of the impugned order after depositing 50% of the awarded amount, and to release the same only in the event of furnishing security by the owner of the vehicle. And by order dated 22/9/2017, this court was pleased to dispose of the IA by directing the learned tribunal to release the 50% of the awarded amount after furnishing security to the satisfaction of the learned member MSCT Nagaon. Following the ratio laid down in the case of Chola Bharatama versus and others versus
No, National Insurance Company Limited versus Chola Bharatama and others. 2004, I've given the copies. 2004, 8
National Insurance Company Limited versus no, that is one. Swarno Singh is also there. Swaran Singh is also there.
In Swan Singh also, Lordship, if Lordship goes by the last paragraph 10.
National Insurance Company Limited versus Chola Bharatama and others reported in 2004 8 SCC page number 517. And that the appellant is ready to pay the remaining amount also, subject to furnishing security by the owner of the vehicle.
And also initiate steps for recovery by the MSCT.
No, to that effect, you have to file a petition before the MSCT.
No, that we will do with the deposit of the amount. What we are supposed to do, Lordship, with the check, we have to file a petition that year. But the direction is in Chola Bharatama also, the direction is that the MSCT has to do the needful. So that's why it is mentioned in this order also, Lordship, last line. That not only security, Lordship, the recovery proceeding should also be begun by the tribunal.
And also to direct the member MSCT to initiate the recovery proceeding as provided under Section 174 of the MB Act Mr. Talukdar, learned counsel for the respondent on the other hand submits that the owner of the vehicle has already furnished security while releasing the 50% amount, 50% of the awarded amount. And he is also ready to furnish security of the same in the event of depositing the remaining amount before the tribunal by the appellant insurance company. Court para, having heard the submission of learned advocates of both the parties and also I have carefully gone through the petition and the memo of appeal and the grounds mentioned therein, and also the impugned judgment and award dated 5/8/2015, passed by the learned member MSCT in MSC case number 349 of 2012. It appears that the learned member by the impugned judgment and award has directed the directed the appellant insurance company to pay a sum of rupees 47,29,396 rupees within a period of 3 months from the date of judgment, that is 5/8/2015, and further provided that in the event of failing to make payment of the amount within a stipulated period, the compensation amount shall carry interest at the rate of rupees 5% per annum from the date of passing the judgment. And further, the learned tribunal directed the appellant insurance company to pay a sum of rupees 1,000 being the cost of the proceeding. It also appears that the appellant insurance company has already deposited 50% of the awarded amount before the, where you have deposited the amount?
Tribunal.
Before the
Tribunal. Because that is the executing court, Lordship. Before the tribunal.
tribunal, okay. Before the learned tribunal. And the same was released by the tribunal as per direction of this court passed in I number 3149 of 2017 in MSC, in the present appeal. By order dated 22/9/2017. And this court was also pleased to direct the learned tribunal to obtain security from the owner of the vehicle at the time of releasing 50% of the awarded amount, and also to initiate step for recovering the aforesaid amount from the owner. Pero, having heard the submission of learned advocates of both the parties, and also as agreed, this court is inclined to dispose of the appeal by directing the appellant to deposit remaining 50% amount before the learned tribunal within a period of
6 weeks, Lordship.
within a period of, yes,
6 weeks.
Talukdar,
5 weeks. I think, yes,
Okay,
6
5
weeks,
weeks.
no problem.
6
Yep.
weeks, within a period of 6 weeks from today. And on depositing the aforesaid amount before the learned tribunal, the learned tribunal shall release the same in favor of the respondent
Payment.
after obtaining security from the owner of the vehicle, and also initiate, and also the learned members shall initiate appropriate step for recovering the aforesaid amount from the owner of the vehicle. In terms of above, this appeal stands disposed of.
Lordship, should there be a protection, because in the trial court, some amount for the children were protected. Should there be a order?
Is there any judgment?
Yes, Lordship. In the judgment, it is mentioned at paragraph, page 11, internal page 11, page 16 of my appeal memo. The daughters were lordship. Given some protection, 2 daughters. But the 5 years have already gone by.
It is further provided that the learned trial court, learned member MSCT shall also comply with the direction issued in the impugned judgment dated 5/8/2015 in respect of keeping some amount as fixed deposit in the name of the minor debtor of the deceased. Two minor debtors of the deceased. In terms of above this MSc appeal is not disposed of.
Highly obliged. Lord.
Item numbers 13 and 14.
My lord, I am the appellant in item number 14, FAO 41/19. My lord, I am being led by senior counsel Diganto Das in this matter, and he's on legs, my lord, in court number 4. So, my lord, may kindly pass over this matter for the time being, my lord.
Yes, any objection?
Nothing, lordship. Provided it happens today.
Lordship,
Lordship, can hear this item number 13 first, 42, lordship. And she is on 43, 41. It's item number 40, I suppose. 14, no?
14.
Yeah, let us start with 42 then, lordship.
Item number 13.
It's against the same judgment, lordship. 2 appeals have been filed.
Who is the other side in that judgment?
Senior counsel Debojit Soikia.
Lordship, he's actually unwell today, so, Lordship, if, adjournment.
Lordship, it cannot be, lordship. It cannot be. I vehemently object to it. Lordship will peruse the records, lordship. Since 2019, this order have been passed and is operating like a final order, lordship. An association which on bogus paper submission, lordship, they have got this interim order and it is acting as a final order, lordship. 19, 20, 21, 22, 25 years, they're enjoying the interim, lordship. And if lordship peruse the records, lordship will see so many adjournments were taken by them, lordship. Sometimes the junior counsel is not there, sometimes senior is not there. Last occasion also he was sick, ill, I know, lordship. But it has I did not object that day. But today it is not like this, lordship. It cannot go on like this, lordship. 5 years, lordship, interim on injunction they have got, and they are enjoying there. If your lordship peruse the orders, in one of the orders it is
Is he
written.
present in the court?
No, your lordship, he's actually very unwell. He could not come today.
Court.
Yes, your lordship.
Lordship, in one of the orders it is written that when the senior counsel was there, he said that my assistant junior counsel was the one who was briefing him. So I think the advocate Pujari is enough, lordship. He knows the case. When in some dates they say that he is not there, so the senior counsel cannot make a submission. This cannot go on, lordship. This absolutely cannot go on. Lordship, in this case, prior to me, senior advocates were engaged. Because of all this, lordship, they found it very difficult. I was being replaced, lordship.
Yeah, I'm ready to hear the matter.
Lordship, will hear the matter, lordship.
No, who will argue? So we will hear the other matter. This matter will adjourn.
It is the same, yeah, yes, lordship. Lordship can. Appeals are tagged together, my lord.
That doesn't mean lordship, one will be present, one will be absent and not. It's lordship, it's against the same order. If lordship is satisfied with their submission, lordship will pass. If lordship is satisfied with my submission, lordship will pass an order. That is
No,
my
no,
answer.
without hearing the other side, I will not pass any order.
Lordship has to hear both the sides.
Yes. That is the requirement.
That's why I need not object to all those things that took time last time also, lordship. Let this court impose costs then, lordship. This cannot go on, lordship.
No, if the council is really unwell, then would it be proper on the part of this court to impose impose cost?
What to say then, lordship?
Mhm.
Nothing to say. I don't have anything to say then.
Okay, let Mr. Bortuzari appear then.
Lordship, he is also unavailable today.
He is also not present in the court today.
No, your lordship.
Last time when the date was taken, lordship, he was very much in the court. And I had asked them again and again, is this date okay? They said okay.
Hmm.
Lordship, I just request him, lordship takes it, not take it. Lordship peruse the record. How adjournments have been taken, lordship?
No, maybe some adjournment may be granted, but
Not
not
some,
in the.
lordship, not all, it is always.
Hmm?
It is not some.
Hmm.
I do understand, even we have difficulties, lordship, but this is always. Sometimes only the matter did not reach in the list. That is true.
Be allowed to submit, my lord. The matter has also been heard on several occasions, my lord. The matter was also kept as part heard by.
Yes,
one
after
of the
part heard
judges,
also
my
they
lord.
kept on taking time, lordship. During the period of part heard, several adjournments were taken, lordship.
Which court heard it?
Justice Parthasarathy Soikia, lordship, and I had released the matter from the part heard. Because during the part heard period also, there were many adjournments taken. Even they were ordered, lordship, even the court recorded that no further time will be granted in this matter, lordship.
Pardon?
There is also record in the record, lordship, which the court says that no further time will be granted. There, all those, everything is gone over, lordship.
Then suggest the date.
Next time your senior will be there. Which date? You tell according.
Any date in next week, lordship.
Kabir, possible?
On 7 November, we can try, lordship.
Oh, lordship, I will be out of station, lordship, 7 November. No. Lordship, let it be this month only, lordship.
Before vacation, we have fixed a lot of cases.
On 29th, it will not reach 29, so many cases.
Lordship, I'll make a mention at 10:30 for hearing the matter, lordship. If possible, I'll pray. 29th, let it be on 29th, lordship.
No, 29 not possible before vacation. After the
Then
holidays.
lordship,
First week of November,
I don't know.
possible, Kabir?
On 5th, then. 5th November, Tuesday.
I have a matter fixed on 5th
5th,
outstation.
7th, 12th, 14th. Anything.
Lordship, can it be this Thursday, no? Or this Thursday,
Holiday.
holiday? What?
Diwali.
24.
Oh, no. The matter has been fixed next week only. As per my instructions. নাই কৰা সেইটোৱে ক'লো প্ৰব্লেম একদম উঠিব পৰা আজি পাৰিলেও
I have come there severely ill also.
Pardon?
As he is lordship severely ill also, he is suffering from fever also. And next to next week, lordship, next week,
Next to next week. That means after 10.
next week কব আপুনি এইটো weekত নোৱাৰিব না তেখেত বেমাৰ
এইটো
আছে।
এইটো উইকত মেম নোৱাৰিব উঠিব পৰা নাই
Let it be on 7th, lordship.
7 hours.
Possible. It's agreed by learned advocates of both the parties. It is provided that recessal is the matter on 7th of November. On that day, an endeavor will be made to finally hear and dispose of both the appeal.
Lordship also will observe, lordship, no further time will be given, lordship.
Okay. It is further provided that no adjournment will be granted.
Item 15.
May it please your lordship. Lordship, this is an appeal for enhancement of our
My
lordship.
cat.
The learned tribunal awarded 2,01,589. This is an
It is injury case or death case?
Injury case. Injury case,
This for enhancement.
yes. And my lord, is 15 of my appeal memo, my lord. Possible find that impugn judgment. Lord, I have exhibited my income tax return, my lord. But my lord, the learned tribunal considered notional income of 5,000. Whereas my lord, my income tax return shows my income is lordship 4,25,874.
Notional income at the rate of rupees
5,000. My lord, may I read the, my lord, that portion, my lord? Page 15. my lord.
whereas your income tax return indicates that
Indicates that, my lord, my income is, my lord, 4,25,874. And
4 lakhs,
874,
4 lakhs,
25,874. Exhibit 3, my lord.
Hmm.
And my lord, it is the admitted position, my lord, in the evidence in record, my lord. It is not also in dispute. They have not disputed that the injured claimant is an income tax assessee. And my lord, his assessment as per, my lord, his income tax return assessment year for 2015-16, his annual income is 4,25,874. That is not disputed, my lord. Another, my lord, point, my lord. It is an admitted position that I was under medical treatment for 6 months, my lord.
Hmm.
I was under medical treatment for 6 months. But my lord, the learned tribunal, by taking my lord 5,000 as national income, my lord, I awarded my lord 30,000 for the, my lord, loss of income during the period of my treatment, my lord. My lord, here I have prepared the, my lord, synopsis of my argument.
Hmm.
Also, I have, my lord, submitted, my lord, a few judgments, my lord. My lord, may pick up my written submissions, my lord. Point number 2, my lord, I have stated, my lord, it is submitted that injured appellant
Ek
is a-
minute, ek minute. What is your profession?
My lord, I am a, my lord, businessman, my lord, proprietor of, my lord, Messrs. GD Tractors. And also, my lord, I am a table tennis coach. And my lord, also I am doing as a computer trainer at JB College, Jorhat, Lodge. These facts were not disputed, my lord.
But have you exhibited any document in connection with your income?
Yes, lordship, income tax return is exhibited, my lord. Exhibit 3, lordship. The tribunal, my lord, while, my lord, tribunal said, my lord, though the claimant had submitted income tax return verification form for the assessment year 2015-16, but he did not adduce any evidence of any employee of income tax office to substantiate his claim. That's why, my lord, my income was considered as 5,000. But, my lord, Supreme Court, in a catena of judgments, my lord, law is settled that, my lord, income tax return is a statutory document, lordship. And, my lord, the tribunal ought to have awarded the compensation, my lord, on the basis of the income tax return, lordship. So, my lord, that's why, my lord, I have clearly, my lord, I have submitted, my lord, in my written argument, my lord, paragraph 2, my lord.
So as per your income tax return, what is your monthly income?
Monthly income is, lordship, as 35,490. 35,490.
So you have many professions. So from which profession you have earned what amount of money? Have you exhibited the document to that effect before the tribunal?
Well, mainly, my lord, I am a, my lord, businessman of, my lord, proprietor of GD Enterprise, my lord. And, my lord, apart from it, my lord, I am doing, my lord.
No, what is the income of that GD?
My lord, I have submitted, my lord, my registration certificate, my lord, of GD Tractor, my lord, as a
GD
proprietor.
Tractor.
That is exhibit.
So
4.
registration certificate is not proof of income.
But, my lord, my proof of income is, my lord, very much established from the ITR, because, my lord, on the basis of that income, my lord, I have paid my income tax, my lord. And it is not that, my lord, it was subsequent to the accident, my lord. It was prior to the, my lord, accident, my lord. I have submitted my return on 31/3/2016, lordship. 31/3/2016. And, my lord, the accident took place, my lord, 20/04/2016. So that is my latest income.
So which judgment you have relied upon?
Yes.
That income
Yes,
tax
sir.
document is
Yes.
a
Yes.
statutory document.
Yes. Lordship may kindly have a look, my lord. 2024 SEC, my lord, 228, my lord, I have. Please, my lord. There, lordship will straightway come to paragraph 10. Paragraph 10. I am reading, my lord. The tribunal proceeded to determine the agricultural income arising from 36.76 AC of land acre of land on the basis of two judgments of the High Court. The tribunal arrived at two different figures by applying the decision and proceeded to determine the agricultural income on an average of the two amounts. The tribunal superimposed the possible value of income from agricultural land despite a clear indication in the income tax return of the income from agricultural land. The method adopted by the tribunal is not sustainable in law. On the other hand, the High Court has proceeded on the basis of income reflected in the income tax returns for assessment year 1997-98. The relevant portion of the return reads as, the tax return indicates an annual income of rupees 2,11,131 in the relevant assessment year. Mr. So-and-so, learned senior counsel appearing on behalf of the appellant contended that other documents were marked which reflected the income of the deceased. Now, this is important, my lord. We are in agreement with the High Court that determination must proceed on the basis of income tax return where available. The income tax return is a statutory document on which reliance may be placed to determine the annual income of the deceased. To the benefit of the appellant, High Court has proceeded on the basis of income tax return for the assessment year 1997 and 98 and not 1999, 2000 and 2001, which reflected a reduction in the annual income of the deceased.
Have you produced this judgment before the tribunal?
My lord, there is no such mention of, my lord, that, my lord, in the judgment. Next one, lordship, 2015, 9 SCC 150, lordship. Lordship got it? Lordship, first head note, lordship. Though claimants file income tax return for two assessment years, 2005, 6 and 6, 7, as per income tax return for the year 2006, 7, income of SSC was so-and-so. Tribunal did not take income of deceased for the assessment year 2006, 7 on the ground that only Xerox copy was filed and the claimants failed to examine income tax authorities to prove the same. High Court chose to calculate average income for two assessment year 2005, 6 and 6, 7. My lord, this was, my lord, done by, my lord, High Court, my lord. But, my lord, Supreme Court, my lord, in paragraph 9, lordship. My lord, I am reading, my lord. Supreme Court says, my lord, it should be, my lord, the latest one should be considered, my lord. My lord, paragraph 9, my lord, the deceased was aged about 45 years and was doing transport business. Though the claimants have filed income tax return for the two assessment years, 2005, 6 and 6, 7, as per the income tax return for the year 6, 7, the income of the SSC was so-and-so. The tribunal did not take the income of the deceased for the assessment year 2006, 7 on the ground that only Xerox copy was filed and the claimants have failed to examine the income tax authorities to prove the same. Instead of taking the income of the deceased as per assessment year 2006, 7, the High Court has chosen to calculate the average of the income for two assessment year 2005, 6 and 6, 7. Considering the age of the deceased and the nature of business he was doing, in my considered view, the High Court was not justified in so taking the average income of the two assessment years. My lord. Next, my lord may kindly have a look at paragraph 15, my lord. Their lordship has considered the latest one, my lord. That photocopy ITR. Paragraph 15. Without adverting to the issue whether additions are to be made towards future prospect or not, it is obligatory on the part of the court to award just compensation. Considering the age of the deceased and the nature of business he was doing, in my view, income of deceased as stated in the income tax return for the year 2006, 7, that is 2,02,900, may be taken as income of the deceased. So, the Supreme Court has considered the latest one, my lord. Not the average one, the latest one Supreme Court has considered, my lord. So on these aspects, my lord, I have relied their judgments, my lord.
Next, my lord. My lord, I have already, my lord, submitted, my lord, it is not in dispute, my lord, that the claimant was under medical treatment for 6 months, my lord. So therefore, my lord, considering the income as per the ITR, my lord, the claimant is entitled, my lord, as per, my lord, for 6 months, my lord, at the rate of rupees 35,490 per month, my lord. And Lordship, I just want to read the, my lord, cross-examination portion of the, my lord, claimant, Lordship. There, my lord, there is not a single question was put challenging that I am not an income tax assessee. My income is not as per ITR, my lord. Not a single question was put. Even, my lord, whatever documents I have submitted, exhibited before the tribunal regarding my expenses, my lord, medical treatment, my lord. That was also not disputed by them, my lord, insurance company. The cross-examination portion of the claimant, lordship, by OP number 3. Cross-examination of claimant by OP number 3. At the time of accident, I was in an Innova vehicle. I know the owner of the vehicle. I was coming in the said vehicle which belonged to my friend Sri Dharmendra Dubey. I did not pay for going into that vehicle. I was coming from Borjar Airport, Guwahati towards Jorhat on the 11th day. I spent rupees 2,49,000 for my treatment. My lord, this is an admitted fact, my lord. But, my lord, the tribunal has, my lord, awarded a very less amount, my lord. That is 1 lakh, my lord.
Oh, whether you have produced any document in
Yes,
support
yes,
of
lordship. I
you
have produced, my lord, all the bills, my lord, whatever expenses I have caused, my lord, that I have, my lord, placed before the tribunal, my lord. That will find, lordship, will from exhibit 6 to, my lord, exhibit 72, lordship. My lord, thereafter, my lord, it is also, my lord, mentioned, my lord, in cross-examination that it is not a fact that the bill and voucher are not related to the treatment of injury sustained by me in that accident. Only that much, my lord. I am still undergoing treatment. I have not submitted any document which shows that I am required to undergo treatment at present. I am yet to be operated for removing the
where is the
plate.
statement?
Okay.
Where is the statement of expenditure?
My lord, paragraph 12, my lord.
No, in the exhibits.
Lordship, exhibit, my lord, from, my lord, the annexer, exhibit 6, my lord. 6 to, my lord, 72, lordship. In my
Alright,
evidence,
where
my
is the statement?
lordship, paragraph 9. I am still under physiotherapy treatment.
No. The statement of expenditure. We have not prepared.
Lordship, paragraph 12, lordship. Paragraph 8 says, my lord, that due to rash and negligent driving of the driver, I have sustained great loss and injury, which might also result in my partial disablement. Moreover, I am the sole earner of my family, living with my wife, a son and a minor daughter who are completely dependent upon me for their livelihood. That I am still under physiotherapy treatment and not fully fit to do my day-to-day work normally, even after a lapse of 2 years. That I have also obtained a certificate for my disablement issued by the office chairman, Medical Board, JMCH, Jorhat Medical, Jorhat Bhai certificate number so and so, dated 17/9/2016. That says, my lord, my disability is of 33% permanent disability.
But it is stated in the said exhibit that it is likely to improve.
Yes, that is there, man. That is there. I am not saying that, my lord, I am
It is not permanent in
disabled.
the, sir.
No, that is not my submission also, my lord. I am not saying that, my lord, I am permanently disabled, my lord. But my lord, but it is that, my lord, my treatment was going on. That was, my lord, my submission, my lord, my statement, and I was during cross-examination. I have categorically admitted, my lord, I am still undergoing treatment. I have not submitted any document which shows that I am required to undergo treatment at present. I am yet to be operated for removing the plate.
Yes.
Lordship, I have relied also one more judgment, Lordship, Rajkumar versus Ajay Kumar, my lord. 2011 1 SCG 343, my lord. That has laid down the general principles relating to compensation in injury cases, the heads under which the compensation is to be awarded. Paragraph 6, Lordship.
Of the judgment.
Yes, Lordship. The heads under which
Paragraph number?
Paragraph 6, Lordship. The Supreme Court has laid down the general principles relating to compensation in injury case and the heads under which the compensation is to be awarded in personal injury cases. So, my lord, pecuniary damages, special damage, expenses relating to treatment, hospitalization, medicines, transportation, nourishing food, and miscellaneous expenditure. Second one is loss of earnings. which the injured would have made had he not injured, comprising A, loss of earning during the period of treatment. Malad, I am entitled to this, malad. Loss of earning, malad, for 6 months, malad, that should be considered as per, malad, my ITR, malad. Malad, loss of user earnings on account of permanent disability, that will not attract, malad.
No, that will not attract.
That will not affect, malad. Malad, one, I am referring only, I am entitled to 1A. 1A. Next, malad, non-pecuniary damages. Damages for pain, suffering, and trauma as a consequence of the injuries. I am entitled to that, malad. Loss of amenities and/or loss of prospect of marriage, loss of expectation of life, shortening of normal longevity. Next line is important, malad. In routine personal injury cases, compensation will be awarded only under H 1, 1A, and 4. Malad, I am entitled only this much, lordship. 1A, and 4. It is only in serious cases of injury where there is a specific medical evidence corroborating the evidence of the claimant. The compensation will be granted under any of the heads B, 3, 5, and 6 relating to the loss of future earnings on account of permanent disability, future medical expenses, loss of amenities, etc. But my lord,
Yes,
here,
Mr. Batra.
My lord, prima facie, it appears, my lord, it's a case of enhancement. My lord. It's very fairly submitted. Otherwise, the income tax return which was placed on record, my lord, the tribunal should have, ought to have, my lord, considered that. But with regard to the medical expenses, my lord, what I propose is that the medical expenses which were in fact considered by the landed tribunal, it seems to be very reasonable. And there were some discarding of the
30,000. No,
No,
what is
no,
the
no.
amount the trial court has considered,
Medical
member has
expenses,
considered?
The award amount is 1,06,000, not 30,000.
Medical.
Yes. And the loss of income is 30,000, which
No, no,
used to be
medical expenses as per the statement, it is more than that.
yes, lord.
few of the prescription, few of the memos were not considered because they were not related to the my lord, the
Treatment.
Otherwise, my lord, it's a case where my lord, lordship will interfere. In fact, my lord, I would suggest, my lord, if it pleases, my lord, it can be remanded back for reassessment. My lord,
No, no, again,
I leave it to your lordship. I leave it to you, absolutely. Right, prima facie it appears, my lord. Without recording that I have considered, my lord, it appears that it's a case of enhancement.
so you have no objection in the event of awarding
Lord,
compensation in this,
that
you
may-
come to paragraph number 6 of the Rajkumar judgment.
Ajay Kumar. Oh, yes, my lord. I don't have that judgment in mind. But only those two heads, my lord, since there is a, the injuries are not so serious, my lord, 1A and
1A, 1,
only under the two heads, my lord, he gets the benefit of that judgment.
no, my lord. I am entitled to, as per head 1, my lord, that speaks about expenses relating to treatment, hospitalization, medicine, transportation, nourishing food, and miscellaneous expenditure. My lord, it's a broad one, my lord. That includes, my lord, transportation, nourishing food, and miscellaneous expenditure, my lord. Other expenses relating to my treatment, my lord, that will also cover, my lord.
But whatever evidence was laid, my lord, lordship will consider that. Yes. I'm not objecting to
Yes.
that otherwise.
And my lord, just my lord, and one more, my lord, so my lord, I am claiming, my lord, as per this, my lord, I am entitled to, my lord, as per, my lord, this pecuniary damage 1 expenses that I am entitled, my lord, clause 1, my lord. Second 1A, my lord, that is, my lord, loss of earning during the period of treatment, my lord.
1A or 2A?
2A, sorry, my lord, 2A, 2A, my lord. 2A. Next, my lord, I am also
But
entitled.
where is the certificate that you have undergone treatment for 6 months? And during that period, you could not perform any.
My lord, my accident took place on, my lord, 20/04/2016, my lord. And, my lord, thereafter, my lord, my treatment was on and on, my lord. That shows from the, my lord, the documents which I have submitted and exhibited before the, my lord, learned tribunal, my lord. And also, my lord, the exhibit, my lord, 8, my lord. That is, my lord, my permanent disablement, my lord, certificate.
That was not proved. That was not proved. Permanent disability. So,
Not exhibited
Not-
before
not
the.
exhibited.
That was exhibited,
no,
lord.
exhibited.
That was
but the-
exhibited.
Well, Lord, it is requirement of the law that it has to be proved by bringing, well, Lord, the author of the document. That was not done. The claimant might have, well, Lord, placed that document.
Marked it as exhibit.
My lord, yes. That cannot be considered.
My lord, I admit, my lord, the claimant has not, my lord, proved it by calling the any member from the, my lord, medical board, my lord, who has examined. My lord, that I admitted, my lord. But, my lord, on the other hand, my lord, when, my lord, because I have admitted I have placed, my lord, when I have submitted my evidence, and when I was cross-examined, my lord, no single, my lord, challenging, my lord, the certificate and my bills and all, my lord, not a single question was put, my lord. So, had they put, my lord, I would have, my lord, call for the, my lord, the concerned, my lord, member from the, my lord, that particular board, my lord, because, my lord, fact admitted, my lord, that need not be proved, my lord.
No, merely because they did not put any question to you during cross-examination, it does not mean that they have admitted it.
And my lord will see the statement of, my lord, expenses which they have provided. The lordship will see, after the serial number 72, there are 1,40,000 and odd amount which was given. And there is no proof of these documents.
Serial number?
72 onwards, my lord, exhibit 72 onwards.
Yes.
Purchase of walker 1,800, regular physiotherapy for last 6 months 36,000, expenses incurred for regular attendant at home 15,000 per month, 90,000, expenses incurred for doctors and compounder visit at home 5,000, conveyance and miscellaneous expenses 10,000. So all these amounts were discarded by the land tribunal, there being no evidence to that effect. So as regards the awarding of the medical expenses, whatever amount has been awarded, I think, my lord, that was reasonably done. As regards the loss of income, which, my lord, my learned friend is claiming, my lord, yes, apparently, my lord, it appears that there is some amount can be awarded. But otherwise, the judgment is, my lord, absolutely correct.
My lord,
Only the loss of income he is entitled. Whatever loss of income the learned tribunal has assessed at 5,000 may be considered taking into account the income tax return which they have filed. But otherwise, my lord, the judgment appears to be just and reasonable, my lord, taking into consideration everything. Nothing more is required to be paid. That's why I told that, my lord, if he has some other documents to prove, but it can be, my lord, sent back to the tribunal, can be assessed again, reassessment can be done, but the award can be passed. But since there are no documents on record, how the tribunal will, my lord, consider those, my lord, amounts? So that was the only lacuna, my lord, which my learned friend tries to point out. But these documents, this, my lord, statement is not supported by the documents which he claims to be have incurred.
My lord, in reply to that, my lord, my lord, may kindly appreciate, my lord, the first head, my lord, pecuniary damages, my lord, which says, my lord, expenses relating to treatment, hospitalization, medicines, transportation, nourishing food, and miscellaneous expenditure, my lord. So, my lord, it comes under the head, my lord, miscellaneous expenditure, my lord. Purchasing of, my lord, worker, my lord. That is very much reasonable, my lord. Purchasing of worker.
That's all right. Whether you have produced any voucher to that effect.
Nothing.
My lord, yet I have not, my lord, produced. But, my lord, the head, my lord, he says, my lord, because when an accident took place, my lord, my lord, and I got injury, my lord. This, my lord, purchasing of, my lord, worker, my lord, that is very much, my lord, necessary. And on the other hand, my
No,
lord,
that's all right, but unless you show that you have purchased it, mere statement will not do.
But my lord, my lord, object of, my lord, the tribunal ought to be, my lord, to pay, my lord, just and fair compensation.
Mm.
And my lord, when, my lord, a
There is no
person
doubt
my
about
lord,
it.
injured, my lord.
Mm.
I got injury, my lord,
Mm.
and then, my lord, under that heading, my lord, under that heading, miscellaneous expenditure court can, my lord, consider, my lord. I am not saying that I am entitled to, my lord, 90,000.
Mm.
Or, my lord, the conveyance and other miscellaneous expenditure 10,000, my lord.
Mm.
But to some extent, my lord, I am very much entitled, my lord, under this, my lord. Otherwise, my lord, the Supreme Court has not put, my lord, miscellaneous expenditure, my lord.
Mm.
And nourishing food, my lord. Nourishing food may anything, my lord. Again, my
No,
lord,
that's all
I
right,
have,
but unless you justify your expenses, how the
well, I am leaving
tribunal
to
will
your
avoid
lordship.
it?
I am leaving to your lordship. But, my lord, my only submission is that, my lord, when I am claiming, my
No,
lord,
no,
2
that's
lakhs,
all right, you are entitled
yes.
to. But where is the document to
My lord,
support your claim?
yes, my lord, that document, my lord, I have not, my lord, given, my lord, because, my lord, expenses incurred doctors and compounder visit, my lord. That my lord, I am not able to produce, my lord, procure, my lord, because normally, my lord, when a doctor visits, my lord, he never issues, my lord, any fees received, my lord, for my home visit, my lord, regarding my physiotherapy. My lord, they don't, my lord, issue, my lord, that kind of, my lord, receipts, my lord. So, my lord, therefore, my lord, I could not, my lord, produce it, my lord. So, therefore, my lord, my humble submission, my lord. My lord, the claimant is, my lord, claiming, my lord, 2,49,598.
Mm.
But, my lord, the tribunal has awarded, my lord, discounted, needlessly, my lord, discounted it to, my lord, 6,000.
Mm.
This is, my lord, very, my lord, less, my lord. And, my lord, so I am leaving to your lordship, my lord, on that point, my lord. But, my lord, I
No,
am claiming, my
tribunal
lord,
has awarded the amount under this head in those expenses where you have submitted the vouchers.
yes. But, my lord, if I, my lord, add, my lord, 1,836.90, my lord, that will come around approximately, my lord, 1,40,000 or like this.
That minus that, it comes to an accurate figure. Whatever my learned friend is claiming, and if you minus those the disputed one, it comes to 1,06,000. Absolutely correct on that count.
But, my lord,
I am, my lord, I am favoring, my lord, my claimant, my learned friend, on count of the loss of earning during the 6 months period.
6 months.
Yes, ma'am. That time, my lord, I prima facie, it appears that, my lord, he was a businessman. He filed an income tax return, and the Apex Court also says that Xerox copy placed on record should be considered. And that much, my lord, it can be considered. Otherwise, my lord, it is very reasonable. Lordship will see the page judgment at page 16, my lord, the heads under which the amounts are awarded. Everything is taken care of. Special diet 10,000, head of transportation 5,000, pain and suffering 50,000. Altogether 2,01,000. So there was learned tribunal had considered the decision of Apex Court, my lord, Ajay Kumar and lives.
Okay.
my lord, my lord, submission is, my lord, under the heading, my lord, pain and suffering, my lord, tribunal has awarded only 50,000, my lord. Yes, that should be, my lord, reasonably enhanced, my lord.
He being a
And, my lord,
businessman running a shop, my lord, there is no, my lord, evidence to that effect that his shop was closed down. And all these things are also there. We don't, my lord, object to all these things. But anyways, my lord, I leave it to your lordship.
and lordship, may one more thing, my lord, I just point out, my lord. While, my lord, the heads, my lord, but the tribunal, my lord, tribunal has given, my lord, special diet, medical expenses. So, my lord, my submission is that, my lord, they have, my lord, separately, my lord, given, my lord, this 10,000 plus 5,000, 15,000, my lord. But, my lord, whereas, my lord, I wish I have, my lord, pointed out, my lord, clause 1, my lord, expenditure in nourishing food and miscellaneous expenditure. So, my lord, this.
Here
this
it is
can be, my lord,
provided a
enhanced by
special diet,
Everything is provided.
10,000.
Everything
Yes,
is
but my
considered.
lord, that should be, my lord, reasonably enhanced. And last point, my lord, the tribunal has awarded, my lord, interest at the rate of 5%, which is very much less, my lord. That ought to be, my lord, 9%. My lord. Because, my lord, I have placed one judgment, my lord. He says, my lord, the last one, my lord, I have placed, my lord. The their lordship will find, my lord, the interest, my lord, the filing of that compensation after, my lord, 2013 onwards and all. Their lordship, last page, lordship will find, my lord, tribunal to have considered, my lord, at least 9% interest. Only this much. Evidence was filed on 14 June 2018. If that
Yes,
is
Mr. Batra, you have any objection in awarding 9%?
My lord, only thing will be, my lord, it can be from the date of my lord, filing of the evidence. My lord.
No, it is, why not from the date of filing claim petition?
I'll not.
There are several
any reason
judgments
to
of the-
object, my lord. I don't have any reason to object.
There are several
But my lord,
judgments. of the
nowadays,
Supreme Court.
7.5% is being awarded. Lordship will consider that.
Not now, nowadays, there is judgment of Supreme Court
Yes,
that
yes, yes, my lord, I am aware.
the principle is laid down in the case of this Upohar tragedy case.
yes.
And that was being followed subsequently by Supreme Court in determining
I'll
the
leave it to your lordship.
compensation in
I'll leave
MSC
it to your
cases.
lordship, absolutely. My lord, without recording that, I have considered, my lord, only prayer will be that.
Okay, we
My
reserve
lord,
the judgment.
one more request, my lord, prayer before your lordship. My lord, my junior colleague, my lord, she got the robe on 5th of October. So if her name can also be recorded.
Okay. Heard Mr. M. Dotto, Learned Counsel for the M.K. Dotto,
M. Dr. Malak.
M. Dotto, Learned Counsel for the appellant, and Mr. Batra, Learned Counsel for the respondent. Number,
One, my lord.
One, my lord.
respondent number 1, and Madam? For respondent number 1.
Yes.
Okay, Mr. Batra and Ms. So-and-so for the respondent number 1. Argument concluded. Judgment reserved.
Obliged.
Deeply obliged.
Thank you, Sir Lordship.
Yes.
Lordship, that judgment for item number
Yes,
12.
yes.
Lordship, that is MSC appeal number 882 of 2018. 882 of 2018. Srimati Ratna Ghosh and 4 others versus Amarjit Singh and 4 others. Item number 11. And Lordship, in 12, I just forgot, Lordship, the statutory deposit may be allowed to be withdrawn by the appellant company. Lordship passed the judgment in the court. itself.
Statutory appeal, statutory deposit.
Yes. Made by the appellant company.
No, that has to be deducted from the,
No, we will be depositing the amount in the tribunal, Lordship. That's Sonali Kolita case where owner has to.
yes.
We will be depositing that in the tribunal, full amount, 50%. Statutory deposit is here with the registry.
Okay.
That amount. Item 12.
The statutory deposit made by the appellant before the registry of this court may be allowed to be withdrawn.
Highly obliged, Lordship.
Yeah.
It shows to be delivered on 17/9/2024.
17/9.
2020.
Heard Mr. K.R. Borough, Learned Counsel for the applicant. Office note dated 21/10/2024 indicates that neither ready card nor answer notice as well as service report has been received in respect of sole respondent, which was issued by order on 12/9/2024. Mr. Borua, learned counsel for the applicant, submits that applicant, referring to the track consignment of the postal department, submits that the item was delivered to the addressee on 17/9/2024. But till that, nobody entered appearance on behalf of the sole respondent. In spite of service of notice upon the respondent. Mr. Borua, learned counsel for the applicant, submits that this interlocutory application is prepared for continuation of delay of 324 days in preferring connected appeal against the judgment and decree dated 14/7/2023 was by the learned civil judge senior division Gulagat in title appeal number 2 of 2019. Mr. Borua further submits that the appeal could not be deferred in time, that the ground for delay has been explained in paragraph number
3, 4, and 5.
paragraph number 3, 4, and 5, and that the delay is not intentional, rather it is circumstantial, and the same has been sufficiently explained, and therefore it is contended to set it, no, contended to condemn the same. Having heard the submission of Mr. Borua, learned counsel for the applicant, I have carefully gone to the petition, especially paragraph number
3, 4, and 5.
3, 4, and 5. It is stated that husband of the applicant expired on 9/11/2020. And she came to know about the case when she received notice in pending execution case being title execution case number 1 of 2024. And though she has consulted with her earlier engaged counsel, he stated that he is unable to file the second appeal. And thereafter, the applicant has approached the District Legal Service Authority, Gulagat, wherein the applicant was asked to apply for certified copy of the entire record. and thereafter taking due approval, certified copies are forwarded to the High Court Legal Service Authority, Guwahati High Court Legal Service Authority. Considering the explanation so forthcoming from the petition as well as from the submission of Mr. Borua, learned counsel for the applicant, this court is of the view that the delay in filing the connected appeal has sufficiently been explained in this application. And therefore, this court is inclined to condone the delay of 324 days in filing the connected criminal appeal. In terms of above this, I stands the disposal. In view of order passed in this IA, now the registrar shall register the RSA and list the same before this court. Preferably on Thursday.
This Thursday one.
Item number 5, make a
Alright.
fixed at 2 p.m.
लिखा मसल में। Yes, Mr. Bora.
My lord, on the last occasion, the facts has already been appreciated by this honorable court. And now I am on my grounds. Last occasion also I have stated, I have submitted that, my lord, the 3 principles of injunction jurisprudence is not discussed in the
Impian order.
And at that point of time, lordship has also stated that in case of mandatory injunction particularly, a higher standard of prima facie case is required. And in fact, that part is also discussed in para 31 of the impugn order. And I have brought, my lord, this case law, para 16, 1990 AIR SC 867, Dorak Kasauji Warden versus Commissar of Warden and others. So para 16, some guidelines are framed. Para 16, my lord. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from the party complaining. But since the granting of such an injunction to a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who succeeds or would succeed may equally cause great injustice or irreparable harm, courts have evolved certain guidelines. Generally stated, these guidelines are: 1, the plaintiff has a strong case for trial. That is, it shall be of a higher standard than a prima facie case that is normally required for a prohibitory injunction. Thereafter is irreparable loss and injury and balance of convenience is mentioned. Now, in the present case, my lords, in the impugn order, this aspect is not taken care of. How he has presented a higher standard of case more than a prima facie case, no hair is there. Thereafter, my lord,
This case perhaps are discussed in the order.
yes, para 31, my lord. Para 31. In para 32, I still remember because the Amin Commission report was discarded in para 32 of the impugn order. And my lord, para 31 at page number 405. Oh, sorry, not page number 405. Sorry, my lord. Four was now, I don't know, 105. Three with six. My lord, sorry, para number 11 at page number 392.
Yes.
392, para number 11. In the case of Dorat Kasaoji Warden versus Kumi Sarab Warden reported in so and so, the Honorable Supreme Court of India held that for the grant of interim mandatory injunction, the following test must be made. ABC. Even then, the order is passed. How he is successful in presenting a more than a prima facie case, higher standard of a prima facie case. No way discussed, my lord. Thereafter, among the grounds, my lord, I have taken grounds. My lord, my ground number D, E, and F, these are all related about these three principles of injunction jurisprudence. And as the three principles are not discussed at all in the impugn order, my lord, so the order that is passed by the learned trial court cannot be said as a revision order. Because while granting any order, while passing any order, and particularly if that order is a appealable one or a reasonable one, the order must be reasonable, so that the appellate court or the revisional court should know at least that what goes into the mind of the judge at the time of passing that particular order. So this is not a well-reasoned order. That is also one of my ground, my lord. I mentioned in F, ground F at page 19, and thereafter I am referring to taken one ground as per section 37, one of the specific relief act, because this application was filed under section 39 of the specific relief act for granting mandatory injunction, and the mandate of law as prescribed under section 37, my lord, 37, it contains in chapter 7 of the specific relief act, and it is chapter 7 is about injunctions generally, preventive relief part 3. 37 is about temporary and perpetual injunctions. So subsection 1, I have taken a ground at G. Subsection 1, it says temporary injunctions are such as are to continue until a specific time or until the further order of the court, and they may be granted at any stage of the suit and are regulated by the Code of Civil Procedure 1908. But in the impugn order, there is no mention of any specific time or until further order of the court. It means for perpetuity the order is passed. Now, if the order is passed in this manner, my lord, as the plaintiff has also sought the relief of recovery of possession and the relief of permanent injunction, so it would amount to passing, partly decreeing the suit by passing this impugn order. And that view has already been taken, which I have shown to your lordship on the last occasion, that is passed in the IA Civil 1421/2024, that is order dated 24/5/2024. A prima facie view has already been taken by this honorable court. Order dated 24/5/2024. Para 4. May I read, my lord? The said stay order has been passed taking into account that from perusal of the order dated 29/4/24, it seems that the learned trial court, while passing those directions, failed to take into account that the mandatory injunction so issued would amount to permitting the plaintiff to enter into the civil dealing, which is the final relief, or for that matters amounts to partly decreeing the suit at this initial stage, that to when the plaintiff even prior to filing of the suit claims to be dispossessed from the civil
Order
dealing.
dated?
Order dated, my lord, it is 24/5.
Para number 4.
Para number 4.
Okay.
So the same is a prima facie view. So now by passing the impugn order, the suit has partly been decreed in favor of the plaintiff without taking any evidence, nothing materials on record. And thereafter, my lord, I am referring to the subsection 2 of section 37 of the specific relief act. This particular order is also not in consonance with this mandate of law, my lord. Because why? Subsection 2 of section 37 of the specific relief act, it says, a perpetual injunction can only be granted by the decree made at the hearing and upon merits of the suit. The defendant is hereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the right of the plaintiff. So these 37 subsection 1, 37 subsection 2, these are all violated in passing this impugn order. Thereafter, my lord, as because a serious disputed question of fact has been raised by the defendants in their written objections. And matter of record is also there, my lord, that I have taken it also as a ground in my ground J, that upon the same facts, the plaintiff has also filed an application under Order 39 Rule 2A, injunction violation, on the same facts. There is also an application for police assistance on the same facts. Now, but passing this impugn order, which is the application that is filed under section 39, the learned trial court accepted the version of the plaintiff to this case as the gospel truth. Now, which may seriously affect the case of the defendants in the injunction violation. Because without taking any evidence, how it can be treated as the gospel truth, whatever he has been stated. But his own document relied in the plain, it says that prior to the institution of the suit, the passage has been blocked. That is, there is one FIR, my lord. That is also discussed in the impugn order. So that is my ground J, my lord. And I have already stated about this prima facie view, which would amount to granting the decree of recovery of possession and permanent injunction. And furthermore, my lord, I want to say that the learned trial court also fails to appreciate the case presented by both the sides in their respective pleadings. Because why? The learned trial court goes beyond the pleaded case of the plaintiff. As the plaintiff has not specifically pleaded that a wall was constructed on the front side of the building, standing over the civil bill and mentioned in the injunction application. So while passing this order now, the court goes also beyond the pleadings of the parties, which is not tenable in law, my lord. And thereafter, my lord, about this Amin Commission report, para 32, already 31 has been shown about the case law, my lord. In para 32 of this impugn order, my lord, first, before going to para number 32, my lord may be pleased to see page number 163. That is the initial order of injunction, dated 6/10/2023. (163) number, please.
Yes.
Second para, my lord. In the result, the circle officer, dispute revenue circle, is hereby appointed as Amin Commissioner to ascertain the following facts. So these are the 4 facts. Number 1, to ascertain the total land of the dark number 691 of Patta number 306. Number 2, whether land described in schedule A, B, C, and D is in possession of the petitioner, that is the plaintiff. With 3, whether the land of the petitioner enclosed by the OPs. Number 4, the exact location and position of land of the petitioner, as well as the OP number 1, 2, and 3. So upon these 4 facts, court sought an Amin Commission report. And the fate of the report was placed. And what is the fate of this report that Lordship will find at page number 405 of this impugn order, page number 405, para number 32, my lord. That is the internal page 20 of the impugn order.
Error number?
32, page number 405, my lord.
Yes.
In addition, the court did not consider the Amin Commissioner's report for lacking clarification on the points raised by the petitioner. No cross-examination or hearing regarding the acceptance or rejection of the report occurred. Furthermore, the opposing parties' counsel argued that the petitioner failed to include the building in the schedule within the plan and that the prayer for mandatory injunction should be dismissed. So this Amin Commissioner report is also discarded by the learned trial court. And now, my lord, the above of this para 32, only for once the para 31 may also be seen. What it says. As the court proceeds with this matter, it will delve into the question of whether the opposing party contravened the order to maintain the status quo throughout the trial proceedings. It is imperative to underscore that the burden of proving the alleged violation rests squarely upon the petitioner, who must substantiate his claims beyond any reasonable doubt. The court will meticulously evaluate all the evidence and arguments presented before reaching a final adjudication on this crucial issue. Now, if this is the view, the court has to wait for taking evidence, then to appreciate the case of both the parties, thereafter only a decision can be taken. Then how at this stage, without taking any evidence, without appreciation of any materials, this order can be passed? That's why order is bad in law, not a sustainable order. And about this Amin Commission report, my lord will find my ground K that this order to issue Amin Commission was passed suo motu, not on any application of the other parties to the suit. While granting the initial ad interim injunction on 6/10/2023, suo motu, the learned trial court issue the order to issue Amin Commission, and thereafter wants to get a clear picture about what whether the land described. These are the 4 points that I have already shown, and in para 32 it is discarded. And as the Amin Commission report is now not accepted by the learned trial court, my lord, so the points raised by the learned trial court is also not clarified as on the date of passing of this impugn order. Then how the learned trial court can say that we have encroached his land? Because it lacks clarification. The impugn order says so in para 32. That's why this Amin Commission report was discarded while passing this impugn order. Now, my lord, thereafter, on the last occasion also I have stated about the death of the defendant number 3. So a person who died prior to the institution of the suit, that person is also implicated in this mandatory injunction, injunction violation, police help, main suit, everywhere. So what has been alleged to be committed by the defendants, not by a single one, jointly. So it includes the defendant number 3. So which shows that the plaintiff has not approached the honorable court with a clean hand and mind. Because a dead person cannot encroach land or can construct one boundary wall. And secondly, my lord, matter of record is there. In the plaint, in the injunction application, thereafter in the injunction violation, police help application, and this mandatory application. The address of the plaintiff is same. He is saying that he is now not in a position for ingress egress to his home. but his address is same. Even after the allegation that his passage is blocked, which shows the falsity on his part. So one who seeks equity must do equity. He should come with a clean hand and mind. Otherwise, not entitled to any equity will really flag injunction. So these are my grounds, my lord, in brief. And I am relying on that judgment, my lord, which I have already placed and which is also referred in para 11 of the MP order.
Yes, Mr. Sinha.
Your Honor, whatever he is saying, I'm not a law professional, so I have prepared a detailed point. So here I have stated everything. I will go through it. May I submit to you? Lordship, the defendant has done all the illegality. And now they have come before the Honorable Court for justice. Lordship, I would like to show the video how they have grabbed my land on 22nd September last year.
My lord, if he shows that, then I have certain objection because this is not filed before the learned trial court also. In connection with this
It is a
mandatory, in
CCTV
connection
footage,
with the
Lordship.
injunction violation, I have certain objections, my lord.
It is a CCTV footage, Lordship. I'm submitting. If Lordship go through it, it will be pretty clear, Lordship. Because I cannot open up 2020 to 2020 last year's September month's evidence right here. Here it is CCTV footage, Lordship. How they have grabbed in front of the police, Lordship. That is the most important, Lordship. Now I have lost my faith on the police administration, Lordship. It is pathetic part as a citizen. And Lordship, they have disobeyed one after another order of even the Honorable Court's, Lordship. They don't obey. Deputy Commissioner has given order last year that they will not deposit any, they will not go to that premises, they will not deposit any soil, they will not construct anything. That order gone. They have, with the help of police, they have encroached my land. Lordship, that is. Then after trial court, this order was passed. 1.5 months, I could not do it. I could not get it executed, Lordship. My family and I could not enter to my home. Lordship, what he is saying, that my address is same. Lordship, if I'm staying at footpath today, will I write my address at footpath? Lordship, I'm staying in rented house, Lordship. My vehicle and my building and my entire premises is damaging day by day, Lordship. It is at risk, Lordship. I'm not being able to use and not being able to touch my vehicle, Lordship. Those vehicles are damaging, Lordship. If I have a road, if I have an access, will I get my vehicle to the scrap? 1 year, Lordship, it's a new vehicle. Only 3 days I have used. That has not been maintained, Lordship. And the entire building I was constructing for my college, Lordship. I don't need that big plot of land. My college is the lone college in entire Northeast, not in entire Northeast, Lordship, entire eastern part of the country. I had that guards, I had that challenge, Lordship. I was trying to establish one sector on that land, for which I need bigger plot of land. That is why I was purchasing that land. That building is damaging, Lordship. He is saying my address is same. Will I write where? And Lordship, if I write today's my address, this evening police will visit me, my residence, and they will detain me. 1 month back, I was attempt to murder, Lordship. I have that document. Whatever I'm saying, Lordship, it is going to be recorded, and these are, I have document, Lordship. I was tried to attempt to murder. Somehow, so that was the situation, Lordship. If Lordship will see the video footage, then it will be crystal clear. That is why they are objecting, Lordship. What is the big deal? I cannot manipulate it. If I manipulate it, I will be held responsible, Lordship. I'll face Lordship has power. Lordship,
Mr.
I have.
Sinha, you see, this is against the order passed by the learned trial court. So whatever material was placed before the learned trial court, that will be considered in this appeal.
Lordship, last occasion also.
We cannot go beyond the pleadings and also cannot go beyond the record.
Lordship, last occasion, Honorable Lordship has asked me certain photographs. I have submitted the photographs. Of course, those were part of the record. Title suit, what I have filed, that title suit, it was a bigger picture, color picture, but with the appeal, it is photocopy, small, cannot be recognized. That is why, Lordship, with the help of IIT Guwahati, I have prepared a model with satellite image, Lordship. That image is already attached with the title suit, Lordship. That image, that model is, that will be crystal clear. Kindly have a look, Lordship. If I have just given it to them. They are saying my ingress and egress is not been blocked. This is the shape of the wall, Lordship. This is the shape of the wall. They are trying to occupy my other part of land. This is my residence, Lordship. This is the front side of the residence. And this is the college building I was constructing. This was the ramp. Kindly see, if I'd like to request you. This is the ramp. It is at the level of my residence floor, because it is almost 15 feet below the road level. This is the ramp. And this is the front side of the building, Lordship. I used to drive down. This ramp was constructed. This is government land, Lordship. This is others' land. These are all others' land. This green part is my 1 bigha of land, Schedule A land, which consists of Schedule C. This is Schedule C, Lordship. This is Schedule B up to here. And this is the wall, this is the bore well, my water source, they have occupied. This is the green part is Schedule D land, Lordship. And this is the construction. Construction is like this. Why, Lordship? Because they want to close my ingress and egress so that, and inside here, Lordship, here my vehicles are blocked. I cannot take out my vehicle, Lordship. I cannot take out my vehicle. If such is the case, borewell has been occupied. They have occupied such a way. And it is This is the satellite view, Lordship. This is the satellite view. I cannot manipulate here. Yes, I can manipulate here, but I am not manipulating because this is the satellite view. As for the ratio of the everything, it has been made. 3D printing has been made. And this is the RAM. This is the RAM. Here it is showing. This is the wall. This is the wall. This is the building. This is building. This is the residence. This is residence. So everything is crystal clear here, but image is not 3D. That is why we have made 3D also. May kindly see that. It will go.
My lord, these are the things not exhibited before the court, trial court. And furthermore, my lord,
Lordship,
southern side is still bounded by NS 37.
southern side is NS 37. Lordship, that is not my land, Lordship. That is not my land. Since I have procured my land in the year of 2017, Lordship. Since 2017, if I have that, I did not have that land. I was having this only RAM portion of that green part is Schedule D. Beyond that green part towards the roadside, that is a government land. And through the government lands mean it is PWD land. PWD roadside, they have a lot of land. So over that land, I have made the RAM. And not only these photographs, Lordship, I have that. This is the title suit. They cannot dispute here. This title suit, Lordship, is having all the photograph, satellite photograph, right from 2017, Lordship. So they cannot dispute. Lordship may kindly see. This is the photograph, color photograph, which has been submitted before the trial court, Lordship. This photograph already been submitted. This photograph, then this building photograph, that 3D model has been done on the basis of this photograph. This photograph showing that my building is this. I had this boundary which has been broken. This is the RAM. They have broken and occupied it later on. This is before the. It is on 14/9/2023, just before constructing the wall. They broke my fencing on 18th August, Lordship, 2023. And they have broken my fencing. And here was one more home laborer's house that was smashed, taken away everything. I have filed FIR. This is 2nd October. Lordship may kindly see, where is the wall? 2nd October, before filing the suit. Where is the wall, Lordship? They are saying that, Lordship may kindly see this photograph so that they cannot dispute. I know, Lordship, this wall is not going to be removed. That is for sure, Lordship, because when
No, you argue on the
Lordship,
merit of the order passed by the learned trial court.
we are really victim of police harassment, because land grabber they do not have that much of guards. Without the help of police and without the help of some law professional, land grabbing cannot be done.
My lord, I have objections, my lord. Law
I have
professionals
not
also he
indicated.
includes.
I have not indicated.
He is referring to me.
I have not
and
indicated.
my clients cannot be turned as.
I have not
Because
indicated.
we have also title documents, my lord.
Mane,
It
it is
a
not
registered
like
gift
this.
deed,
It is
registered
like
sale deed, my
this.
lord. But I have objection.
The Mondirot kun ase moi
He
call koa
cannot
nai.
say against me.
I have not indicated him, Lord.
Law professional.
He is
What I
not
am
only
saying?
the Lord. He is not only
No,
the law professional in this
no,
country,
you
Lord.
can't say so.
He is not only the law professional in this country, Lordship. There are
I am
plenty
pursuing
of
the case from the
lakhs of
from the
people
very
are there.
beginning. He is referring
Lordship,
to me, my lord.
No,
lakhs
no.
of people are there. Lakhs of people are there.
Mr. Sinha, you come to the
Lordship,
order of the case.
Lordship, last occasion, Lordship has clearly indicated that prima facie point is higher than any other facts. I have,
No, that is the requirement.
that is
And that is stated in this case also,
Lordship,
which has also been discussed by the learned trial court.
trial court, Lordship, yes. So I have sorted out almost 11 points already submitted, Lordship. The Honorable Court can grant a temporary mandatory injunction, number one. Number two, my absence from my undisputed land, building and other assets has led to irreparable damage, which is continuing and alarming. If the wall is not removed, I cannot enter my home to protect my properties and use it until the final disposal of suit. Appeal, it will go to appeal, and then after it will go to Honorable Supreme Court. So till then, I have to sit quiet. I cannot enter to my home. If my property is damaged, who will compensate, Lordship? Nobody. Will this temporary mandatory injunction order partially be decreeing the suit? It has already been discussed later on. Defendants claim that the wall was constructed before the suit. Defendant entered my land on dock number 691 on 22/9/2023. And defendant has admitted that my ingress and egress have been blocked. My family was rescued by, Lordship, this is most important. My family was rescued by police commissioner on her request letter. My wife had to write to the police commissioner that rescue us because they have blocked my ingress and egress and they have harassed me. So on 23rd of last September, police commissioner himself visited and with his senior official, lady official, my family was rescued. That was the situation. But that time, wall was not constructed. It was human. 150 people were there. Uncivilized people were there. That is why I would like to show the video, Lordship, which they are objecting. Of course, they will object. Trial court had collected suo motu Amin Commissioner report. The trial court has not decided the ownership of the suit land. Temporary mandatory injunction be granted for a period. Of course, currently, I do not have any claim against that person that has been discussed. As on today, it is fact, I do not have. No mutation, that I will go later. Honorable Court has granted a point number one. Honorable Court has granted a temporary mandatory injunction. Para 11 of order dated 6/4/2024. In that, this order, it is in para 11, it is clearly stated, in this case of Dorab Sawas G, Warden versus Komi Sorab, Warden reported in AIR 1990s SC 867. The Honorable Supreme Court of India held that for the grant of interim mandatory injunction, the following test must be met. The plaintiff has to demonstrate a strong case, what they are saying, which should be of a higher standard. So this has been discussed. Then again in para 12, Honorable Supreme Court held in Hamad Ahmed versus Abdul Majid, the grant of interim mandatory injunction is not prohibited and it can be granted in appropriate case. Further, the court held that an ad interim compulsory injunction is to be given not at the asking but on intense circumstance to protect the right and interest of the parties so as not to frustrate their right regarding a mandatory injunction.
So,
At
Siddharth,
time,
that is the
Lordship.
principle laid down by the
Lordship,
Supreme Court in that
Lordship.
case.
Lordship.
You show me from the impugned order, in which part of the order the learned court has discussed your prima facie case?
Lordship, it is page number 6, Lordship, which I have submitted just now. This point number 3, will this temporary mandatory injunction partially be decreeing the suit? It is the order para 33 of order dated 6/4/2024, granting the petitioner's request for the removal of structure and opening up of the right of way for vehicular movement would not equate to granting a decree for the recovery of specific possession or a permanent injunction. It is discussed, Lordship. And para 2 of page number 9 of the Honorable Supreme Court in Dorap Sauji Warden decided that the relief of interlocutory mandatory injunction are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done or restoration of that which was wrongfully taken from the party compelling. So I have already, that video is okay. I will not go to that. Defendants claim that wall was constructed before filing the title suit. Lordship, for last 1 year, they could not prove it that they had wall on the suit land. They could not prove it. Last 1 year at trial court as well here also. And para 28 of order, the plaintiff have promptly filed when after construction, after the wall, after violation of status quo order of the Honorable Trial Court, the plaintiff has promptly filed an immediate application seeking a temporary mandatory injunction pertaining to the erection of boundary wall encircling the specific Schedule B property and integral part of larger Schedule A property. The detailed photographic documents, Lordship, detailed photographic documents furnished by the petitioner unequivocally illustrates the completion of boundary wall encompassing the structure, thereby causing obstruction in a manner that effectively bars access to the plaintiff's entryway. So it is proved. Next, para 29 of order dated 6/4/2024. Question was established prior to the commencement of the legal proceedings. This claim find further validation in the testimony provided by the petitioner's wife during the interaction with officer in charge. My wife's letter, which they are saying that my wife has admitted that my ingress and egress was blocked by constructing of wall. It is blatant lie, Lordship. She never wrote like that. Testimony provided that the petitioner's wife, during an interaction with the officer in charge of Jalukbari PS on 24 of September 2023, in her statement, she acknowledged that opposite party and a significant group of individuals, reportedly comprising 100 to 150 antisocial elements, obstructed the petitioner's rightful passage and proceeded to erect temporary structure on the vacant plot of land such statement not only strengthen the opposite party's argument regarding the pre-existence of the boundary, but also sheds light on the unlawful acts undertaken by the aforementioned parties, which have played a pivotal role in exacerbating the dispute at hand. In para 30, the court has observed that the petitioner's wife did not make any claim regarding the construction of permanent boundary wall surrounding his boundary on dated 24/9/2023. However, upon further scrutiny of the document, particularly the photograph submitted during the injunction application in Miss Case number 1000/23, it became evident that a bamboo fence had been erected in front of the petitioner's building. Furthermore, the submitted photographs clearly indicates the presence of a concrete boundary that obstructs the petitioner's right of way. So all the photographs after and before has been submitted, Lordship. When they have entered to my land, suit land, Lordship, with the help of police, it is on 22/9/2023. The defendant has admitted they have admitted that my ingress and egress has been blocked. They have admitted that. My entire family was rescued by the police commissioner after a letter from my wife requesting for rescue. Then 4 has admitted in his FIR on 18th Lordship, that FIR copy already annexed, Lordship, Annexer 1 or page number 16, Lordship, the same paper book. So they have admitted on their FIR, Lordship, that is সন্মানপূৰ্বক নিবেদন এই যে যোৱাকালি ৰাতি 17/8/23 তাৰিখে মই মিৰাজ শইকীয়াৰ পৰা কিনি লোৱা দলেচা মাটি দাগ নম্বৰ 692, দলেচা মাটি 692. 692 is a government land, but দলেচা মাটি কিনি লৈছে পট্টা নম্বৰ সোয়েনসো আৰু শংকৰ কুমাৰ দাসৰ পৰা পাৱাৰ অফ এটৰ্নি কৰি লোৱা 2 কঠা দলেচা মাটিৰ দাগ নম্বৰ 691 পট্টা নম্বৰ 306ত মাটি পেলোৱা আৰম্ভ কৰো আৰু 18/8/2023 তাৰিখৰ ৰাতিপুৱালৈকে মাটি ভৰাই ফিল আপ কৰো. This is important. তাৰমানে 18 তাৰিখ, that means, and next FIR, next page, Lordship, 17, their FIR on 23/9/2023, their FIR, it is to inform you that on 22/9/2023 at about 7:30 p.m. I, along with my laborer, constructing fencing and house at my own land, power of attorney holder, which described below. The land was identified by Revenue Circle Officer Kamrup. So that means Revenue Circle Officer Kamrup has demarcated their land jointly with Assam Survey team on the same day in presence of the neighborhood landowners and police officials. Accordingly, peacefully, I had started my construction work. That means 22nd, they have constructed their work, some work. The below noted accused person, along with some goons with conspiracy and illegally trespass our land. So that was their FIR. Lordship may kindly see, and they have admitted on their written statement, which says that written, it is in appeal petition, page number 343. They have their appeal petition, page number 343. They have stated, accordingly, the Circle Officer, Guwahati Revenue Circle, in presence of additional Joint Director of Assam Survey, Officer in charge Jalukbari Police Station, and other co-pattadar of Kesapatta numbers 366, 306 and 185, including the plaintiff, demarcated the land, and accordingly the answering defendant possessing the same. Lordship, this speaks many things, Lordship. On last occasion, they were shouting that this is our ancestral property and we were possessing since our ancestral, their ancestor. So this is the fact, Lordship. Defendant 4 has filed FIR already. I have gone through, Lordship. The circle officer, most importantly, the blatant lie will now come out. What it is, Lordship? The circle officer in his letter dated 33/2024, the circle officer letter, I can show, Lordship, that page number 484 of additional reply affidavit, Lordship. 484, Lordship. Page number 484. Here it is written, whatever they were saying, that they have been given position, demarcated the land. On that, I wrote a letter to circle officer, please clarify this letter. On that, my letter, reply to my letter, the circle officer on 33/2024 উপরোক্ত বিষয় সন্দৰ্ভত প্ৰসংগ আপোনাৰ ইংৰাজী 27/3/2024 তাৰিখৰ চিঠি উপৰোক্ত বিষয় সন্দৰ্ভত আপোনাক নিম্নলিখিত ধৰণে তথ্য দাঙি ধৰা হ'ল। 1 নম্বৰ, যোৱা ইংৰাজী 22/9/2023 তাৰিখে জালুকবাৰী মৌজাৰ ফদিলাপুৰ গাঁৱৰ ডাক নম্বৰ 691 আৰু 693 নম্বৰ ডাগৰ মাজৰ সীমা নিৰ্ধাৰণ কৰা হোৱা নাই। কোনো মাজৰ no demarcation in between the dag. উক্ত গাঁও মৌজাৰ ডাক নম্বৰ 691 এজামালি পট্টাদৰৰ মাজত জোখমাখ কৰা হোৱা নাই। How can they say, Lordship, that they were given possession by the circle officer, survey officer, police officer, and so and so? So this is most important, Lordship. Nothing has been done with the police force and the uncivilized people. They have encroached my land. This is the proof. 691 কোনো পট্টাদৰৰ সীমা সঞ্জয় দিয়া হোৱা নাই। যোৱা 22/9/2023 তাৰিখে হৈ যোৱা সীমা নিৰ্ধাৰণ PWD গুৱাহাটী NH ডিভিজনৰ চিঠিৰ প্ৰসংগক্ৰমে কৰা হৈছিল। They have stated on their appeal petition or their written objection at trial court, they stated that we were approaching the circle office. No, Lordship. It is clearly stated, যোৱা 22/9/2023 তাৰিখে হৈ যোৱা সীমা নিৰ্ধাৰণ PWD. It is not between Pattadar of 691. It is between PWD and the owner of Pattadar of 691 or 693. So along the road, whatever was, when the PWD land was demarcated, nothing with the between the Pattadars, Lordship. And I have the survey report, Lordship. I have the survey report, Lordship, which shows 691 doesn't touch the national highway entirely. 691 few portion, Lordship may kindly see that model on the satellite view. It is showing that 691 few portion is touching the highway. Even whatever they are occupying, only other than my part of land, other the Schedule B land, other part is also not touching the national highway. There are other dug, Lordship. That is why they desperately need this ramp, need this Schedule D land. It is a master plan, Lordship. Lordship may kindly see this survey report, Lordship. Here it is map also. May kindly. And Lordship, the circle officer has already clarified that they have not handed over any possession. They have not demarcated any pottadars amongst the pottadar. The trial court has collected, so moto collected Amin Commissioner's report, Lordship. The Amin Commissioner's report, they have gone through para 32, but para 13, Lordship, but the para 16 is different, Lordship. Amin Commissioner's report, para 16. Para 6, Amin Commissioner, regarding the Amin Commissioner's report, para 16 states that for considering the temporary mandatory injunction, which is purely temporary arrangement, temporary mandatory injunctions, they have not considered the Amin Commissioner's report. They have not considered it. But as on today, Lordship, what is in front of us, Lordship? The Honorable Trial Court has already passed injunction order. The injunction order, Lordship, is annexed as annexure to page number 18 and 25, Lordship, in my recent paper. Is in 18 to 25, page number 18 to 25. It is Honorable Trial Court's order dated 13/9/2024. May we go to page number 24, Lordship. The page number 24, it is written like this. In the report, the Amin Commissioner stated that the petitioner is in possession of 3 kotha 16 lesa. Despite of my 1 bigha, Lordship, I am in possession of 3 kotha 16 lesa, where my other land has gone 1 kotha 4 lesa. They have occupied. Whereas the opposite party having possession over 1 bigha 16 lesa, Lordship. They have occupied 1 bigha 16 lesa. At this, as on today, I am not going to other part of 691, Lordship, but 691 other part, a title suit against them is pending. The original Pattadar is crying. Original Pattadar has filed revenue appeal. And revenue appeal, why they have gone to revenue appeal? Lordship, during 2015, the handwritten document was converted to computerized. Those days were going on. During that period of time, somehow they could write their name in 1 bigha without any valid documents, without having any valid document, Lordship. Because whatever on last occasion they were saying that they were given 1 gift deed in the year of 1958. It is off the record I am going, Lordship, if Lordship permits me.
No, not necessarily. We are primarily concerned with the impugn order.
So that part is also under challenge. Next, Lordship. So Amin Commissioner's report has now crystal clear, has been accepted by the Honorable Trial Court and clearly stated that I am in possession of 3 kotha 16 lesa despite of my 1 bigha, and they are in 1 bigha 16 lesa. It is crystal clear, Lordship. And Lordship, in 6 April 2024, Lordship, 6 April, the Honorable Court has passed this order to remove the boundary wall. They have not removed. Opposite party disobeyed to the honorable courts. Then after, honorable court has instructed the police and Nazir, OC Jalukbari and Nazir, to remove the structure. The Nazir visited 3 times, but OC did not cooperate. He said, we cannot do it. Which force has prompted them? Which force has stopped him not to execute the honorable court's order? God knows, Lordship. Then after, another order and letter has been sent by the trial court itself that within 7 days it should be removed. That order also not complied with. Then after 20 days, they came to the honorable court with revision petition. Revision petition was dismissed first day. Then after, they filed this first appeal. So in this first appeal, so that means after 45 days of the order, which supposed to be, that order supposed to be executed within 30 days, 30 or 31 days, because court has written a specific letter to the trial court, to the OC, that you demolish this within 7 days. I have that letter also annexed here. So that also not complied with. And finally, this order was stayed. So that is why, Lordship, I'm sure this wall will not remove, but it is my duty, and in future also I should not have any regret that I have tried my level best. Trial court has not yet decided ownership of the suit land. As on today, it is not decided, Lordship. It is discussed in para 37. The issue of right title and interest over the entire entity of the land in question will be thoroughly examined during the impending title suit 691/2023 trial. Yes, Lordship, they have, it is true that temporary mandatory injunction should not be granted for indefinite time. It is also, I also admit that it should be given till the disposal of title suit. Some time should be mentioned, not indefinitely. As on today, I do not have claim against dead party, that is opposite party number 3. So, in presence of both the party, Lordship, now they are saying that against dead person, I had claim, but on their presence, on the trial court, this name was striked. There is an order. It is reflected that it is the order was passed to strike down the name of dead
That's all
person.
right. If a trial court has passed any such order, then the matter ends there.
Lordship, yes. Again, his respective counsel has raised. That is why I am going, and that has already been discussed in para 24 of that order and 26. Most importantly, Lordship, this I will come later on, Lordship, and certification of official letter, clarification of letter 2010, help over is defendant twisted the meaning of local officer. So, Lordship, mainly is, if suppose this wall is, this shape of the wall is this, their intention is very clear, Lordship. Their intention is very clear. Who will construct such kind of wall, Lordship? If they dispute it, I'm giving it to them. They can check it. If they find it, they can object it later on, and they can prosecute me. Lordship, if suppose this wall means my ingress and egress is not removed, more than any other grounds or more than any other law. That road is using by me, that road is constructed by me, that road, through that ramp, not road, it is a ramp. I was going to my home. If my ingress and egress is not removed, I won't be able to utilize my own residence, not house. It is residence, Lordship. It is residence. When I say residence, when it is emotional. We are away. His daughter, my son is same class.
No, no, Mr. Sinha.
So if my property is going to be damaged, Lordship, who will compensate that, Lordship? The Honorable Trial Court has understood that. Before the Honorable Trial Court, we could show each and every photograph. And in fact, I was not there. I was sitting behind I was not arguing that time. Counsel was there. Honorable Trial Court called me and asked me to explain each and every photograph. I was explaining in front of them. And that is why Honorable Court could see the photograph, read the photograph. And that is why Honorable Trial Court has given me ingress and egress. I am not going to construct anything there, Lordship. On the suit line, I am not going to construct anything. I will just get the access. And that land, that was not a land, Lordship. On last occasion also, I was saying that it was a pitoni, 15 feet pitoni. Other side, you can see, Lordship, that green part is still pitoni, 15 feet from my courtyard level, front courtyard level, from Schedule D land. From that level, the pitoni base level is another 15 feet to raise, to deposit 15 to 16 feet. Then it will come to the level of suit line level. And then after my residence. So that pitoni is still there. I was not procuring land. I was procuring clay and pitoni, Lordship, and water. It took me since 2017, it took me 3 years to develop, at least to make it habitable. And suddenly I was residing. Because why I have resided there, Lordship? Such a very dangerous place it is, surrounded by uncivilized people. So it is a dangerous, because I had that passion to take risk, to establish something. That is why to monitor the construction, to construct at that place is very difficult, Lordship. And I was monitoring like a chowkidar. So I was residing like a chowkidar and supervisor like that. And that is why I was residing there. And on that, my vehicles are damaged. All 1 year, Lordship, gone. My entire property, if I see that it's damaging day by day, it is up to the Lordship whether ingress and egress will be given to me, or I'll have to wait for another 3 years, 10 years, or whatever. It is up to the Lordship. That's my humble submission, Lordship.
My lord, in reply to whatever he has said, for 2-3 times he has shown the shape of the wall. What sort of a wall it is by this tool. Page number 237. This is his application for mandatory injunction. Page number 237, I am referring to the second line from the top. Paragraph 29, continuation of paragraph 29 from 236.
Yes.
The second line, my lord, from the top.
Hmm.
And on 10/10/23, when the petitioner visited his suit land, he has found that the opposite parties has raised construction of concrete wall surrounding the building of the petitioner and thereby close the petitioner's right of way. Now, surrounded, but this is the same as we have shown. So if the building is surrounded, can it be the same of the wall? So either he is telling false here or this model itself is false.
Lordship.
Number one.
I'm not going to other part of the
His
site,
application.
because my concern is front side at this, as on today. I cannot go, I cannot ask the honorable court to remove everything. The honorable
Pardon, my
court
lord.
has given only ingress and egress, lordship. They need not to remove, not only this, other part also need not to be removed, lordship. That will be final outcome of the title suit, lordship. I'm not going to that point.
My lord, further,
Small point, if raised, then I will take every small point, lordship.
this schedule A, B, C, and D of the plane. So schedule A, that is 1 bigha land, that is also in the south covered by NS 37. Schedule B, which is his purchase land from one registered sale deed, that land is also by NS 37. Schedule C land, which he claims that there is a agreement for sale, not sale deed, and ₹1 power of attorney. On the basis of that, he has made the construction. And this schedule C, here land of Nitu Lohkar. And schedule B also south, NS 37 and land of Nitu Lohkar. Nitu Lohkar is his wife. And he is saying today that I am surrounded by some sort of uncivilized people, including his wife also.
No, no,
It
no.
means
Mr. Bora,
this gentleman, Zahirul Islam, is also uncivilized. His pro forma defendants are also uncivilized. We are also there, we are also uncivilized. This is his version.
no, 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 no.
So, my lord, my point is that whatever he has been stated or whatever today has been given before this, before your lordship, OP is not served. These are all beyond pleading. These are the afterthoughts. And why he is against the police? Because in connection with two
No,
cases.
no, no, Bora, no, we will not go beyond the pleadings and the record of this case.
So this is my reply.
Hmm.
Because this model itself falsifies whatever has been stated in his petition for mandatory indemnity. And he is now claiming this ingress and egress of our land. Because the southern side, there is NS 37 clear in that model also. Why he doesn't go from that part? Also, some portion land belongs to his wife. You go from the southern side. In the earlier occasions also, it was advised to him, you access through the southern side.
Who advised?
Honorable Justice Devashish Barua, during discourse, it was said that you can avail the southern side. You
I
go.
was asked,
Why you are insisting on
Probably
this part?
respected counsel has
That
forgot
is the
that.
schedule D.
Probably respected counsel has forgot that. I have clearly stated that to raise again that part, the southern part of the schedule, entire schedule B land is again deep, very deep. And I have to deposit soil. I have to make a separate ram. I have to construct such a way. I have to now take permission from police, because every day police is against of me. Every day.
Perhaps
Every
in
day.
connection with some other
Lordship,
cases. He is
then
on bail in
second
two cases.
is, yes,
Bail is granted by this
No,
honorable.
Yes,
no, no,
Lordship.
Mr.
Yes.
Bora.
yes,
No, Mr.
I was-
Lohkar. Yes, any other reply?
Nothing, my lord.
Nothing.
So, my lord, he in fact has not justified the order, whatever his submission before this court today, honorable court today.
Hmm.
No justification has been given. So, order is devoid of any merit. So, liable to be set aside and passed.
order, if order is Lordship, I have prayed before this Honorable Lordship, that if ingress and egress is not opened up, I will have to wait for another probably 10 years, 15 years. And they need that. That is why they constructed such a way that I become compelled to sign wherever they want. Nowadays, it is happening not only with me, it is happening many places, Lordship. And Lordship knows everything. I'm a simple person. I'm a single person. I do not have any other business, Lordship. I'm fully devoted for the upliftment of the education, Lordship. And nothing else. I do not have a single business. And they have stated many things, Lordship. And I cannot access that part. Lordship, that 693, whatever respected council has said, anything is, even my chowkidar has been threatened by the police. It is my chowkidar.
Police is not a party to the proceeding.
Police is nowadays, it is home is party, Lordship. Already made home has been made party in this case.
No.
Yes,
for the
Lordship.
purpose of
Why
calling
is-
for a report,
Whatever.
the honorable court
Home has
directed
been
the
made
government
party. And
advocate,
Lordship,
CA,
Lordship, home has
furnish
been
a
made by first day itself. Home has been made party and police, the honorable court was asking that why wall has not been removed till today despite of order. So later on, I don't know. So home is party, and second is Lordship, the
No, Home Department has not been arrayed as a party in this proceeding.
Lordship on the first day order,
No.
home has been made party.
A report was called for, my lord. So far I remember.
No.
So after getting the report, stay order was passed by this honorable
No,
on 24/5. So far I remember.
Home
On
Department
17,
has not been
4
made a party in this proceeding.
first day
Only a report was
order,
called.
it is reflected.
From the police.
Home has been made party. And report from home has been called for. And
No, mere calling for a report does not mean that he is a party to the proceeding. Home Department is a party to the proceeding.
Lordship, it is a contempt of the court that police has not obeyed to the honorable court's order. They have not complied. It is contempt of the honorable trial courts. If wall is not removed, Lordship, I'll have to wait for 10, 15 years. That is the.
No, your argument is over and please don't submit anything.
Deeply obliged.
Always.
No, the court has requested the additional senior government advocate to apprise the court. Why no action was taken by the officer in charge Jalukbari Police Station on the order dated 29/4/2024. Home Department has not been arrayed as a party in this proceeding.
Yes, ma'am.
Heard Mr. Boda, learned counsel for the appellant, and Mr. Sinha, Bikram Sinha Laskar, learned respondent in person. Argument concluded. Order reserved.
Deeply
Always.
Item 16.
Before hearing, we have one application, the order 41 rule 27.
For?
The I number 3334 of 2019, Lordship. On last two occasions, the respondent had taken time to file objection against that on 16 to 23 as well as 24/9/24. They have not filed any objection against that. So before hearing, Lordship will take up this application first because we are praying for allowing us to adduce additional evidence of the FIR, Lordship. Because we are alleging fraud in the case, Lordship. The FIR was against a different vehicle, different kind of vehicle, and the claim case was made out against a different vehicle.
Yes.
What's if I'll argue on the merit of the case orally.
No, regarding this, IA?
Yes, Lordship. From the record itself, it is proved why they cannot file any additional affidavit regarding that.
From the record.
From the record, lower court records.
This FIR, Lordship, in the claim petition, they have mentioned it.
Where is the FIR, madam?
Lordship, I have annexed it, translated copy at 6 and the original copy at 8, Lordship, in my eye. And in the appeal also, I have annexed that. Relevant part, Lordship, এখন auto rickshaw. Auto rickshaw di goi thakute. Mane he was a police constable, Lordship, the deceased. Auto rickshaw di goi thakute, that is the FIR. But in the claim petition, what they said was that it was a DI vehicle. That is why this FIR, Lordship, number is also mentioned in the claim petition. They did not prove the FIR, Lordship, in the trial court. They did not exhibit it because of that discrepancy, Lordship. FIR, the translated copy I mentioned. With due respect, I hereby state that on 26/12/2007, at about 3:30 p.m., my brother UBC Prahlad Sharma, along with one home guard and one accused, were traveling in an auto rickshaw from Hajo Court to Guwahati Central Jail with an accident at a place named Barnodi, and my brother, along with the other people, sustained grievous injuries from which they were immediately taken to Hajo PHC for treatment. The doctor of Hajo PHC sent them to GMC. Due to their serious condition, they were brought to GMCH. But as the injuries of my brother were serious in nature, he was admitted at GNRC Dispur on the same night at 7:30 p.m. But during the course of treatment today, that is 27/12/07 at 2:50 p.m., doctor declared him dead. So, sir, I pray. So, Lordship, this here it is mentioned as auto rickshaw. But in the claim petition, Lordship, and the trial court record is there, Lordship, in the claim petition, they say that.
Have you enclosed it with your appeal?
Yes, Lordship, with appeal also and with this
Page number?
Appeal, Lordship.
No, the claim petition.
Oh, claim petition, no, Lordship, they haven't. Oh, no, I have not. Claim petition is the. Claim petition, column number 22, Lordship, where they have mentioned about the incident. Before that, they have mentioned it as a Mahindra pickup van. Lordship, here I'll read. Column 22.
Yes.
On the fateful day, that is 26/12/2007, at about 3:30 p.m., the deceased person, late Prahlad Sharma, was standing on the roadside at Bordodhi and met with the accident when a Mahindra pickup van. So here they said he was standing on the road and Mahindra pickup van had dashed him. But in the FIR, Lordship, they have mentioned that he was traveling in the auto rickshaw. And when
Taking one
yes, that's why we
accused to the
yes, that's why we are saying fraud. And if fraud is there, Lordship knows United versus that any court, any tribunal, lordship, at any point of time can interfere with the judgment, lordship. United versus Rajinder Singh, this is very old case in that. And after that, the lordship, Ramji Gupta and Anil and others versus New India, all these cases, lordship, Apex Court held that if there is fraud, lordship, so my humble submission, lordship, that we may be allowed to prove the FIR so that the real fact comes before the court.
Whether that FIR was exhibited before
No,
the member?
no. It was not. That's why we have filed this IA, lordship, under Order 41, Rule 27, to allow us to adduce only this. And this FIR number was also mentioned in the claim petition, lordship. That is column 9. Name, address of the police station under the jurisdiction of which the accident took place was registered. Hajo PS case registration as Hajo PS case number 789 of 07. And this FIR, lordship will see this is same. Hajo PS 28907. And it is also mentioned state versus driver of auto rickshaw. Accused.
So this before invoking this provision, you have to satisfy why you could not produce the additional evidence before the learned trial court or before the member, notwithstanding the exercise of due diligence. There's a requirement of Rule 27.
Yes, lordship.
AA.
Yes, lordship. Lordship, this we have mentioned in our petition also.
So that FIR has been mentioned in the claim petition also.
Yes.
Number of the case.
Yes.
Then why you could not produce the same? You have to satisfy this court only, then
Yes,
we will be
lordship.
able.
Lordship, this was we have mentioned in our application at paragraph 5. This was provided to the dealing counsel, lordship. Dealing counsel did not take any step, lordship. And after the judgment.
Now can you take that benefit here?
No. I know Ibrahim case, lordship. In Ibrahim case, it is mentioned that that benefit does not come, lordship. But then when I'm alleging fraud, lordship, in that Ibrahim case itself, lordship, at paragraph 36, lordship, it is mentioned, I'll just read. Where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit, and interest of justice clearly renders it imperative that it may be allowed to be permitted on record, such application may be allowed. This is paragraph 35 of Ibrahim case, lordship, wherein in detail order 41 Rule 27 was discussed, lordship. So, lordship, and my is that and another part is that, lordship, that the Rule 27 B, lordship, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause, lordship. Substantial cause, in my humble submission, lordship, here we are saying that the judgment has been procured fraudulently by making false statement. So that becomes a substantial cause in my humble.
No, but how it can be? Because they have mentioned the case number there in the claim petition. the
Yes,
police case number.
yes, but they are not telling the truth, Lordship. They have mentioned the case number.
Mm.
That is why they have not exhibited the FIR, because if the FIR is exhibited by them,
Mm.
then the claim petition itself is.
No, they're not supposed to. No. You cannot compel them to exhibit that affair.
No, I'm
It
not.
is their
comparing-
prerogative.
Yes,
It is
that
how
is-
they would prove their case.
Yes, correct.
Mm.
That is, Lordship is very much correct in that.
Mm.
But then, who is asking for equity should come with clean hands, Lordship.
Mm.
It was their
No,
duty.
that is the principle in equity.
Huh.
Uh,
And here they are claiming for benevolent legislation and compensation and all
Mm.
that, Lordship. And in that, if Lordship finds that they have played some fraud on the court, and
Mm.
by that fraud they have procured the judgment, Lordship have ample power, Lordship.
No, that's all right. There is no dispute about it.
Yes, Lordship.
But merely because they have not exhibited the FIR before the tribunal, claim tribunal, can it be said that they have played fraud upon the
Lordship.
court?
Yes, Lordship, because in the claim petition, they mentioned that the deceased was standing by the side of the road and the Mahindra pickup came and hit him, and so he died. But in the FIR, it is mentioned that he was a police personnel who was coming with another person and the accused in the auto from Hajo police station to Central Jail. At that point of time, he
Was on duty.
Yeah, and at that point of time, the accident took place, and ultimately he was taken to hospital. He died. That is the FIR. But in the claim petition, they are disclosing a totally different thing, Lordship. A totally different picture, that he was standing by the road.
Why don't you produce the ZD entry of the concerned police station? Because if the person was deputed to take the accused from Hazu court to Central Jail,
Yes, there
then
will be a,
definitely there would have been one ZD entry in
entry.
the
that we can do,
concerned place.
Lordship. That we can do.
Hmm.
We can ask
That
our
will
investigator to.
that will establish whether he was standing by the side of the road or he was proceeding in
Exactly.
auto to the
Exactly.
Central Jail, Guwahati.
Exactly, Lordship. Because there must be a command certificate, because
Definitely.
without the command certificate, he cannot take the accused to the, there will be. So, okay, Lordship, I'll ask my insurance company to further get these documents by employing a investigator.
Lordship, it is 2007 accident was occurred, Lordship. Until that single penny was not deposited before this court, we have not taken it is different thing. But that IA was also not any order was passed regarding stay. That is different thing. But this court kindly come to that FIR. This FIR was they have get it on 4/12/2009. And MSC case was filed on 2008. They have filed a WS. In the WS also, they have not mentioned their officer's name. If you Lordship go through the record also, you will get that. And in cross-examination also, these things have come. May just read, Lordship. The cross-examination of PW1, this is Nilima Devi, Lordship. মই মোৰ স্বামী মৃত্যু দেখা নাই, এখন পিকআপ ভেনে মোৰ স্বামীক খুন্দিয়াই দিছিল। শ্ৰী হিতেশ শৰ্মা মোৰ দেওৰ হয়। This is that হিতেশ শৰ্মা the FIR who have lost the FIR as per them. ঘটনাৰ পিছত মোৰ দেওৰ হিতেশ শৰ্মা এখন এজাহাৰ দি ঘটনাৰ বিষয়ে জনায়, এইটো সত্য নহয় যে মোৰ স্বামী অন্য দুজন মানুহৰ লগত পিকআপ ভেনত গৈ থকা অৱস্থা বৰধদী নামৰ ঠাইত গাড়ীখন এক্সিডেণ্ট হয়। তেখেতৰ as per their version that they are proceeding in a pickup van. And এইটো সত্য নহয় যে মোৰ স্বামীৰ বয়স 50 বছৰ বেছি হয়, মোৰ স্বামী HSLC পাছ কৰা নাই, চাৰ্টিফিকেট আলটো দাখিল কৰা নাই, মোৰ স্বামী আসাম পুলিচত কনষ্টেবল চাকৰি কৰা কোনো প্ৰমাণ পত্ৰ জমা দিয়া নাই, এক্সিবিট 4ৰ প্ৰমাণ কাৰণ কোনো আদালতত অহা নাই, এইটো সত্য নহয় যে এক্সিবিট 4 মিছা হয়, মোৰ স্বামীয়ে ইনকাম টেক্স বুলি মই গম নাপাওঁ, এইটো সত্য নহয় যে মই বেছি টকা দাবী কৰিছোঁ, এইটো নহয় যে মই ইঞ্চুৰেঞ্চ কোম্পানীৰ পৰা কোনো ক্ষতিপূৰণ মই পাওঁ। They have got it on 4/12/2009. They may have filed one additional WS before the Honorable Court. We have filed our evidence.
Why this discrepancy then? if the FIR
Lordship,
was filed by,
from my knowledge, this is there. He has some psychological problem. From my knowledge, that from claimant's person, I have come to know she is some psychological problem, and this FIR was also written by some other person, and he will just find it. Now, how this come, I have no idea. And again, after completion of rituals, for correction of this FIR, another FIR was filed by the wife of the deceased.
We do not have that.
whether that FIR is available with you?
Lordship, I can show you.
কোন থানায় আপনার হাজো?
Whether any police case was registered?
That
That
is,
registered.
Yeah,
Then
it
what
was
happened to
registered,
that
but-
case?
unless 298, that is Hajo PSK.
289, 289.
289, 289. Under section 279, 338, but
It was certified or not certified?
Sarsit, I think not, have not filed. That
Till date.
till date.
that itself shows lordship. A person has died, our own high court judgment is there, Hananya Rabha, where that, and also apex court, Lalita case lordship. Regarding FIR, and if there is a fatal accident, then the police has to do the needful in that, to take it to the logical conclusion. Hajo PS 828 number and claim petition of the same number is given lordship 289, and accident information report also mentions 289.
Let us do one thing.
Yes, lordship.
We implement the state of Assam as party here. We will issue notice to them to produce the record of that GR case before this court.
Fine, lordship. That will have everything.
Kobe, anybody available government side? কোনোবা এজন মাতা? Third, Miss R.D. Mazumdar, learned counsel for the appellant. Then Mr.
KK Doctor.
K.K. Dotto, learned on that.
1, 2, 3.
Respondent number 1, 2, and 3.
Lordship,
1, 2, and 3.
claimants in the.
Mr. Gogoi, in this appeal, the appellant has alleged that the claimants have played fraud in the court and procured a judgment. And in this case, we deem it necessary to call for the GR record from the trial court, or if it is not solicited from the concerned police station, you have to produce the record of GR case number, Hajo PS case number 289 of 2007. Miss R.D. Mazumdar, learned counsel for the appellant, that she has filed one interlocutory application being IA civil number 334 of 2019 under Order 41 Rule 27 of the Code of Civil Procedure for allowing the appellant to produce additional evidence in the form of a certified copy of FIR dated 27/12/2007 of Hajo PS case number 289 of 2007. And referring to the FIR dated so and so, Miss Mazumdar has pointed out that in the said FIR, it has been alleged that this is along with one homeguard was taking one accused from the court at Hazu to the Central Jail Guwahati and in one auto rickshaw and then met one accident near Barnodi and sustained grievous injuries, and subsequently during the course of treatment he died on 27/12/2007 at about 2:50 p.m. at GNRC Dispur. Thereafter, referring to the claim petition, Ms. Majumdar submits that in the claim petition, the vehicle is described as one Mahindra pickup vehicle, and that at the relevant time of accident, the deceased was standing by the side of the road. And under such circumstances, Ms. Majumdar submits that this IA number 3334 of 2019 may be disposed of by allowing the petition filed by the insurance company for allowing to exhibit the FIR of Hazu PS case number so and so so and so. In view of the submission of Ms. Majumdar, this court deemed it necessary to implead the state of Assam as respondent number 3.
No, but should there will be 5 because already 4 are there.
Where?
Already 4 respondents are there. State will be 5.
Oh, okay. Yes, respondent number 5. Yes. Respondent number 5. Let notice be issued to the respondent number 5. By this. To the respondent number 5. However, no formal notice is required to be issued since Mr. Gogoi, learned government advocate, appears and receive notice. However, extra copy of the petition will be furnished to him during the course of the day if possible.
No, tomorrow. like,
Tomorrow.
It is now 4.
I will indicate state of Assam represented by Commissioner Secretary, Department of Home Lordship, then specifically given.
Department of Home,
Lordship, Commissioner Secretary,
Okay.
Department of Home Lordship.
represented by Commissioner and Secretary to the Department of Home, Goktav Assam. Goktav Assam. It is provided that Mr. Gogoi, learned counsel, learned government advocate, shall produce before this court the record of Hazu PS case number. No, first they will obtain an instruction of whether it has been surseated or not.
Lordship, Lord.
Shall apprise this court on next Monday,
Hearing matter on Tuesdays or Thursdays.
Tuesday.
Hearing no hobo etia. Etia to again it will come for orders, I suppose. Hearing on.
It will come on the hearing.
Then Lordship, first week of November, Lordship.
No.
It has to be passed.
Next,
Lordship, let it be on Friday then. Let this week because he can obtain a telephonic
Instruction
instruction.
only.
So let it.
I have to communicate with the Commissioner Secretary Home Department. They have to Lordship to the
ask
Hazu police station. Lordship.
নহলে PP Julie হাতক কলে বাড়িও
Otherwise, if lordship, the public prosecutor is given direction, they can directly. And I cannot, if lordship may direct to the OC to the Hazu PS lordship, then.
No, you produce. Your
No,
department.
lordship may direct the OC to the lordship may record in the order, then Hazu.
No, you obtain it.
No.
That's why we are implementing the state of
No,
Assam.
lordship, I will place it lordship. Lordship may direct the OC to the Hazu PS to give the.
No. কি কলো লাইনটো? No, not procure, sell apprise this court on next Tuesday. Monday.
On 30 lordship, 30.
Tuesday. No, 30th. On 30th, as to whether Hazu PS case number so and so is surseated or not, and if surseated, where the case is pending now, and whether it has been disposed of or pending for trial. List the matter on 30 accordingly.
I pay for a copy of the order also.
A copy of this order will furnish to Mr. Gogoi during the course of the day.
I also another prayer. Kindly reflect my name, otherwise I will miss the matter.
Your name? No, already.
Costly slow.
Rest shall reflect the name of Mr. Gogoi, learned government advocate. That's for the respondent number 5.
Item number? Item number 17.
This appeal has been filed on 2 sets of grounds. One relates to quantum, the other relates to liability. The quantum part is the deceased was a bachelor, and the deduction for personal expenses is a very well established question. It should be 50%. It isn't taken as one third. That is number one ground. Number 2 ground lordship is that he was just merely about 22-year-old boy. His income has been considered as 7,000, which is a notional income. Lordship now courts easily apply for family holders. It's been lower than that. And third is rate of interest has been considered as 8%, which lordship I think can be scaled down a bit.
Pardon?
I think lordship can be scaled down a bit lower.
8%. From 8%. Why?
Three grounds lordship.
Why?
Lordship, fixed deposit rate of interest and fixed deposit.
Maybe, but there is a judgment of Supreme Court.
Lordship,
Not one judgment, several judgments are there. It should be 9%.
I also, in that case, argue on that point, submit on that point.
Then
Lordship,
why should we depart from that judgment, that direction?
Lordship, I'll just, it's a ratio that has to be considered. There, because Supreme Court judgments are varying here, Lordship. It's not 9% always. It's even as low as 7%, 6.5%. So, their number is there. So someone has conveniently cited maybe 9%. Lordship, that 9% judgment, I'll Lordship illustrate on that, Lordship. It's a ratio that has to be looked at because it's a discretionary power, Lordship. The tribunal has the discretion to use, apply whatever rates under section U. So, there is a Kosnuma Begum versus New India Insurance Company. That's where the only judgment where I have found it's very well established and followed the which has given a reason why what should be the rate of interest. It was Lordship decided that the rate of interest prevailing at the year purpose. Because in Lordship there's a very famous judgment Upahar tragedy. Yes. It is given as 12%.
Not 9%, it was around 12%, because Lordship, it keeps parity with the bank rates, Lordship. If today now, I don't think any bank pays more than 7.5%.
You have that judgment with you? Upahar
Kaushika Begum, I should be.
Upahar
okay.
tragedy case.
Lordship?
Upahar tragedy case.
Upahar tragedy, yeah, I did not have it. But Kaushika Begum, which lays down the year,
Because the reasons given in that case
yes,
is followed in determining the rate of interest in subsequent cases by
yes,
Supreme Court.
Lordship, at that point of time,
Hmm.
I remember I was in service at that point of time. We used to buy NSCs. NSCs used to double in 5 years. Lordship. Rate of interest used to be 16% in NSC. Some fixed deposit instrument they used to pay in 6 years, the amounts used to double. So that 12% was in that case.
No, you
probably
produce
much
that
lower.
judgment before
Now
this
that-
court.
no,
We'll see
in that case only.
further to be taken into account while determining the rate of interest.
It also have a good collection of judgments on that level. I will also prepare a write-up on that judgment interest rate. But Lordship, the basic points are the 2 points, I think Lordship, that my learned friend will also agree. The deduction should be 50%.
50% as per that Sorla Verma case. Yes.
So subsequently confirmed by Pranay Sethi.
Hmm,
It's a
hmm.
settled question.
Hmm.
Second point is Lordship, I leave it to reason is 22-year, but there's no certificate by any employer. He was supposed to be a brass utensil, bell metal artist. That means he used to work in, there's certificate by the Gram Panchayat. He used to work as a bell metal industry, but there's no certificate by the employer that he used to work somewhere. 22-year-old probably would not be much of expenses coming out of his teens only. So that 7,000 I think also can be scaled down.
7,000?
7,000 per month. Because the tribunals in 2019, the case of 2019. Even the family holders used to be considered in the bracket of 9,000, 7,000, 8,000. But for a boy, it can be 5,000. I think it will be fair enough.
No, merely because he is unmarried, can we fix his notional income as 5,000?
No proof, Lordship. It's not given any proof that some brass metal, bell metal in the owner has employed him. Even that kind of proof is not there. So it can be
one notification, usually Supreme Court follows one notification issued by the Labor Department, perhaps, fixing the rate of this remuneration to the labor, daily wage worker, carpenter.
The experience, all these are also taken into consideration because there are unskilled workers that the minimum wages act that unskilled workers, semi-skilled workers, and skilled workers.
Yes.
That
That
depends on the
notification
age,
recent
how many years of experience he has, then he becomes into semi-skilled. Whether he has any technical, then he comes into skill category. Not
That's
everyone.
all right. You produce the prevailing
Yes, I'll leave it to Lordship.
the prevailing notification during the year 2019 when the accident took place. 19.
The interest part, I leave it to Lordship. I just produce the judgments, caution not done. Because that's the only judgment which is given a rational reason why interest should be what. But it's very clearly indicates it can be flexible from time to time, depending on the bank's rate of interest. And the Lordship, the other part which I have not come in is again one aspect I don't have very clear idea, Lordship. In this, what has happened? The court itself came to a year that there has been violation of policy concerns. But what has happened is owner died. Owner of vehicle also died. His father has been implemented as a being a legal year. The vehicle was not registered, and there's no driving license also. The tribunal has recorded that. But tribunal was, it appears, did not want to pass on the liability to the father of the deceased. Even I am not very sure whether the father should be asked to bear the liability of the created by his son. That's one legal question, Lordship, I leave it to you. Tribunal has come to a judgment, it will be very one long para is there. There has been violation, very clearly violation on the part of the owner of the rider, but he also died in the process. The claimant or deceased the claimant's son and the owner of the vehicle, two-wheeler, they both died in the accident. But there has been violation of policy control because there's no registration, no driving license. The tribunal learned member has come to that conclusion that there has been violation of policy condition.
Then how you have been directed to pay the compensation?
That is what Lordship. I don't know if he is wrong or right, Lordship, I remember. But felt that there is no state. Lordship, I can read out a part of the judgment.
Which one?
This judgment tribunal, tribunals. May I read, Lordship?
Number 25.
Paragraph 25, no, page 20.
Number 25, page number
Paragraph 25.
25.
Second paragraph.
Second paragraph.
I'll read out this document. Paragraph 25. In this case, at the time of argument, the learned counsel of the insurance committee took the plea that the deceased, namely Raju Taludar, was implicated as a party in this case, but the legal heirs of Raju Taludar have not been made parties in this case. Learned counsel for the insurance company also.
You were reading paragraph number?
25 also.
25.
Of the judgment.
Yes.
In this case, at the time of argument, learned counsel for the insurance company took the plea that the deceased, namely Raju Taludar, was implicated as a party in this case, but the legal heirs of said Raju Taludar have not been made parties in this case. Learned counsel for the insurance counsel took the plea that at the time of accident, the owner cum rider of the vehicle Raju Taludar did not have license, which was reflected in both claim petition and in the motor accident information report, Form 54. I have found that in this case, the owner of the offending vehicle, Raju Taludar, died on the spot due to the accident. Though his name was initially inserted in the claim petition, but the same was amended by the order dated 6/11/2019. And after that, his father has been implicated as party, considering the fact that he is the legal heir of the deceased Raju Taludar. It is found that Raju Taludar, the insured, was not a registered owner of the offending vehicle. That is, the vehicle was not registered at the time of the accident, as revealed from the accident information report, Exhibit 1. Further, I have found that Exhibit 1, that the age of the owner was 22 years. That is, he was measured. No any income of the owner has been proved by the insurance company during the inquiry. So it is not proved that father of Raju Taludar has inherited his entire estate or part after his death. Therefore, though the father was implicated in the opposite party, but no liability would be vested upon him. In Exhibit 1, in the accident information report, there is no mention of driving license in the name of the owner cum rider. So late Raju Taludar had neither registered the vehicle in his name nor had driving license at the time of accident. Though he violated the conditions of insurance policy, but he died. Therefore, the pay and recover formula cannot be applicable in the present case at hand. The OP number 2 is not entitled to recover the awarded amount from the father of late Raju Taludar, who was the owner of the insurance. This lordship is there. We are not.
So can you produce his husband that whether on account of violation of the policy condition, this award can be made or not?
I remember I'm not having exact judgment on this point, but there is a judgment of Supreme Court. If minors drive the vehicle, the parents become responsible. The father becomes.
No, he is not minor. He is at
It's not
22
minor,
years.
It's on similar lines, whether a father can be made liable for the default of his son. For the minors, that is that judgment is there, but the provision of law is also there. But in this case, I'll have to look up some judgments in this case. And then get lots of right of interest judgment and the I'll see in time. The son may not have left anything for the father. He probably did not have an estate also. That something get it from the estate of the son. It's a very
So
interesting
in
question
which part
law.
of the judgment trial court learned member has dealt with the notional income?
Paragraph number 14, Lordship.
Paragraph number
14.
Last. So one document was produced.
Exhibit 5.
The said document was not proved by the issuing authority before this tribunal, except Exhibit 5. There is no other document showing capability of the deceased to earn rupees 12,000 per month. That also is important. It's just a survey by an association. They are not a certifying authority. The tribunal has used the discussion of the but I will listen on the higher side. That's not. That evidence is lordship. That's not evidence, lordship. Some document, some organization has signed the document. They don't come to prove it. There's no employer.
And therefore,
certificate of trade DA like.
therefore, the learned member has fixed the notional income.
Even notional income can be high. That is my only ground. I leave it to you. It's notional, but I think considering his age and the
No, that is the power is discretionary. No?
yes, but then
If a reason is assigned by the trial court by the member MSCT, this court cannot replace the
I
same.
can only pray that in similar circle, in similar year, what is the year? What at that in the year 2019? How much was what is the trend of notional income? That has to be.
No, that's why I'm asking you that minimum wage is.
That also is one value, but let's say minimum wage also someone maybe at the lowest scale, unskilled category that can be considered. 2019, not because he hardly has had any age to acquire some kind of skill in it. I've read the definitions of skilled, unskilled, that they are categorized. How much?
So this a bell metal artist.
Now 3 years experience for any to come into semi-skilled category, then something more to that, some degree. Let's say I'm just making a year that in comparative year, I'm not saying as absolute rule. But maybe let's say this present.
And deduction.
That is not say, I think.
At page number?
No objection to that.
At page number?
Yes, there are number 17, Lordship.
17.
There are 21.
17.
It's shown in. Yes, there are 17.
So it is admitted that he was bachelor at the time of accident.
Yes, Lordship.
Bachelor.
Parents had a claim.
So as per that Sorla Burma case, deduction should be 50%.
Yes, Lordship.
Then this enhancement to 40%.
That is-
That is correct.
that is-
As per that
Yes,
ratio.
yes. No dispute on that.
So we can dispose of the matter.
Yes, Lordship. Only that point, Lordship, I mean, I'm not, I cannot say confidently. I would have liability part, Lordship. Whether pain recovery in this case can be.
No, it is your case unless you produce relevant materials, what to do?
Can the ratio of that judgment or in case of minors be applied?
Hmm.
Because parents finally, if minor does it, the parents become liable.
Hmm.
Here the son had done the same thing, driving without a license, driving without.
No,
a registration.
if you want to
It's a
produce some
violation
material
of some
before the
act.
court, if you want to produce some material before the court, then we can grant you time.
You can do that part. I can put the relevant provision of law where the parents become liable for minors here. Even if it's not a
Then
minor,
let
but
us
he
fix
has-
it on Thursday.
Not it?
Let us fix it on Thursday then.
That's the day after tomorrow. Day after tomorrow. Yes, sir.
Part third.
I'll just try lots.
Third, Mr. Argusami, learned counsel for the appellant, and Mr.
Yeah, motion.
M. Hussain, learned counsel for the respondent number 1 and 2. Third in part, leaves the matter on Thursday.
Item 18.
18 may paper today, Lordship, would not be finished. Lordship.
18.
It will take time. Because Lordship, the records of another case decided by this honorable court is also tagged to it. The prayer I had made in before the honorable court was that in that case, the owner of the vehicle had come before the High Court, that his vehicle was falsely implicated, it was not there. The honorable High Court Lordship had directed the CID to give a report. On the basis of this report, just found that there's another vehicle, not the vehicle which was Lordship
Involved.
involved. Honorable Court was pleased to tag, call for the records of that case, when the High Court had Lordship has directed the CID to make an inquiry and give a report. And my prayer is similar in this line, that there is a yellow. The owner of the vehicle is
This
here.
has been already
No,
dismissed,
no,
my lord.
let me finish that. The owner of the vehicle is also here. And the owner of the vehicle had vehemently protested or written, filed a written statement denying, gave evidence. Even here, the owner of the vehicle is active in this, and vehicle is not involved. So this where Lordship, there are cases, Lordship, there's one famous case, United India versus Rajendra Prasad Singh. Their Lordship, when there's a trial court had rejected a review prayer on the ground of fraud. High Court rejected the ground of fraud. Then Supreme Court, in fact, praised the insurance, in fact, said that admired the insurance company for taking it to Supreme on the grounds of fraud, and it was allowed. So fraud is something that vitiates everything. So maybe best we should look at the truth, Lordship, what has actually happened. If the owner of vehicle so insistent, it was never involved. So he doesn't
Now,
know.
what is your submission?
My submission, Lordship, is that I'm
You are not ready today.
ready. I'm ready. Lordship, but I thought it will take time, so I.
It will take time.
Yes, it will take time. It will fix Lordship. It's a part and fix within this month.
Part third.
No objection, because already that was my lord, award passed by the already Planet Court below, my lord. It was, well, my learned friend has filed this appeal. Earlier, initially, this is second round of this appeal, my lord. Earlier also one appeal filed, my lord. In that case, it was, my lord, remand back. My lord, Justice P.J. Soike, my lord. Therefore, he lordship was found that, my lord, the earlier order, what has been passed by the Planet Court below is not correct. Because the award was not given by the Lanet Court below. It was rejected in the MC case. Subsequently, it was, my lord, that
The order has been set aside and my lord remand back the matter to the court below. Thereafter, court below, my lord calculated the amount and awarded this rupees something 31,08,000. But my learned friend has filed this appeal. So second round of litigation. So anyway, lordship may fix it, my lord. We have also Thursday.
Next Thursday.
November, lordship.
November.
November.
But as a part of
Okay. 19 November.
yes.
Heard Mr. R. Goswami, learned counsel for the appellant, and Mr. H. Das, learned counsel for the respondent number.
I'm respondent number 1, my lord.
Respondent number 1, Mr. Rosit.
1, 2, 3, my lord.
1, 2, 3, Mr. Rosit for respondent number 4. And you?
Five, sorry, five.
5. Yes, 5.
5. You have 5. 4.
I'm for five.
Okay. Heard in part, list the matter as parted on 19.
Item 19.
Pleasure, lordship. This matter is similar to yesterday's item number 28 and 29, lordship. Here the issue is pending before the Honorable Supreme Court, lordship. And the tentative date of hearing was given on, lordship, 18/11/2024. And lordship have posted the matter, yesterday's matter, after 18/11/2024, lordship.
My lord, yesterday after going back, I have conducted a very deep and thorough research and I found a Supreme Court judgment in an identical question of law wherein the SLP was preferred by the NF Railway from the Guwahati High Court and the SLP was dismissed by the Honorable Supreme Court on the very similar same question of law, identical question of law, my lord.
Take it that from him. Today, time will not permit to hear the matter.
Lordship, today's matter was fixed at 2 p.m. However, the same was not reflected in the cause list. Lordship may kindly fix.
Sorry, we will not fix the time.
Lordship.